comments should be addressed through the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best we can, and we appreciate your patience and understanding in this regard. Welcome to our witnesses. They are here to answer any technical questions that any people may have. Familiar faces to all of us. From the Department of Justice, Matthew Taylor, Senior General Counsel and Director General, Criminal Law Policy Section. Natalie Levman, Senior Counsel, Criminal Law Policy Section. And Leah Burt. Very nice to see you. From the Department of National Defense, I see we have Lieutenant Colonel Matt McMillan, Director of Military Justice Implementation, Office of the Judge Advocate General, Canadian Armed Forces, and from the Department of Public Safety and Emergency Preparedness, Amy Johnson, Director General Firearms Policy, Stacey Alt, Director Corrections and Criminal Justice Division. They'll be switching in and out. Okay. Okay, so before we begin clause by clause, I would like to provide members of the committee with a few comments on how committees proceed with the clause by clause consideration of a bill. As the name indicates, this is an examination of all the clauses in order in which they appear in the bill. I will call each clause successively, and each clause is subject to debate and a vote. If there are amendments to the clause in question, I will recognize the member proposing it, who may explain it. The amendment will then be open for debate. When no further members wish to intervene, the amendment will be voted on. Amendments will be considered in the order in which they appear in the package each member received from the clerk. In addition to having to be properly drafted in a legal sense, amendments must also be procedurally admissible. The chair may be called upon to rule amendments inadmissible if they go against the principle of the bill or beyond the scope of the bill, both of which were adopted by the House when it agreed to the bill at second reading, or if they offend the financial prerogative of the Crown. During debate on an amendment, members are permitted to move sub-amendments. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended. Once every clause has been voted on, the committee will vote on the title and the bill itself. In order to reprint the bill may be required if amendments are adopted, so the House has a proper copy for use at report stage. Thank you to all the members, and I look forward to a productive meeting this evening as we go through clause by clause on Bill C-16. Okay, so we will start at the beginning. Pursuant to Standing Order 75-1, consideration of Clause 1 short title is postponed. So I will call Clause 2. That's NDP 1, is deemed moved pursuant to the routine motion adopted by the committee on June 17th, 2025. Ms. Gazan, technically I think I need consent to have you speak. I don't.
No, you don't actually, Mr. Chair. If I may, point of order.
Well, you do too.
No, I don't, Mr. Chair. Okay. I want to explain the terms on which Ms. Gazan and I are here because it seems that other members may be unfamiliar. I'll ask your consent to do it now, or I'll do it when my First Amendment comes up. Up to you.
I've just asked the room for consent from the voting members of the committee for Ms. Gazan to speak. I have it, so I'm going to let her speak. Thank you. Go ahead, Ms. Gazan.
Thank you so much, Chair. This amendment was actually brought forward by Noel. This amendment is about ensuring that survivors of intimate partner violence receive legal supports and protection while testifying against an abuser, ensuring that they are not re-victimized and denied their right to speak up against violence and injustice. This amendment would extend protections for women experiencing violence and abuse, including testimonial aids and prohibitions on cross-examination, ensuring these are in place for all offenses committed against an intimate partner. What matters for vital protections like these is the context of domestic violence, not the type of offense committed. This is a suggestion supported by leading women's organizations, and I urge my colleagues to vote in favor of it to ensure victims' rights are upheld in this bill.
Thank you. Is there any other interventions on this? No? Okay. Shall NDP 1, hold on. Shall NDP 1 carry? Okay, that wasn't, we do a recorded vote. I couldn't tell whether it was Was there any yeas on that? No? Okay, so it's defeated. Okay, so now we'll go to G1, which I believe is Ms. Latanzio? Defeated.
Sorry, Mr. Chair. Okay, so this is a technical amendment that I'm making, so it's necessary because we are broadening the scope of offenses to which testimonial aids, no contact orders may be ordered. This motion proposes an amendment to the interpretive provision in Clause 2, which would be required if motions to amend Clauses 38 and 40, testimonial aids, and Clause 59, no contact order are passed. So this would remove the testimonial aids provision listed in paragraphs 3.12, C, D, and E. So for those reasons, I moved this amendment.
Thank you, Ms. Latanzio. Mr. Lawton?
Just if I may, a question to the officials on this. Just with the scope of it, would this exclude the use of testimonial aids in intimate partner violence cases? Okay.
It would include that, but it would make them apply to all offenses against intimate partners.
Thank you.
So I don't need consent.
Technically, no, but if someone
Yeah, okay, all right. No other comments? Okay. Shall G1 carry? Yes, okay, thank you. Okay, so we're moving on to PV1. Now, it is...
Mr. Chair?
Just bear with...
I'm sorry. I'd
No,
like to
Miss-
remind the
I have
chair.
to read something procedurally, if you just bear
All right. Thank you, Mr.
with
Chair.
me.
Of course.
Thank you. PV1 is deemed moved pursuant to the routine motion adopted by the committee on June 17th. Also, an amendment to PV4 extends the concept of coercive or controlling conduct to apply to a relative in addition to an intimate partner. The committee may want to come back to this after doing PV1, PV2, and PV3 because those other, so we might want to deal with PV4 first before dealing with PV1, 2, and 3. Ms. May?
You know, I hold you personally. The motion of June 17th is not routine, and I'd just like to put on the record that if it was not for the committee choosing on its own volition to pass that motion, I would have, as would Ms. Gazan, as members of parties that are not quote-unquote recognized, the right to bring forward substantive amendments at report stage. This motion was a device to avoid our rights initially instigated by the Prime Minister's office when Stephen Harper was in power and has since been carried into every committee. As a result, we are more or less required, if we want to put forward amendments, to come to committee. It's not our choice. It's rather coercive, but the motion has been carried. And as such, that's why I object to the notion that Ms. Gazan needed anyone's permission to speak. We are here because the motion was carried on June 17th in this committee, which says that if we want to present an amendment, this is the fashion in which we do it. Our motions are deemed moved. We are, under the motion, permitted to speak
you know what?
to
I'm
our
going to interrupt
amendments.
you just in the interest of time. We are allowing you to speak.
Yeah, you don't have a choice.
There's no.
That's your motion
okay,
that you
there's
carried.
there's no issue with that, Ms.
Yeah.
May. So why don't we proceed to the amendments, and then we can save ourselves a lot of time.
Well, thank you, Mr. Chair. I go to a lot of trouble to prepare amendments for committees, and I just wanted on the record that this is not my choice. I have more rights if you hadn't passed the motion. I'll now move to my amendment. Thank you. As the committee knows, many representatives from groups that represent the elders of this country, seniors, so the Dementia Justice Canada, the Elder Abuse Prevention Ontario, the Canadian Network for the Prevention of Elder Abuse, and others have seen in this bill, which I support, C-16, because it is important to end coercive control over intimate partners. But there's also an issue of coercive control over seniors who are relatives. And in that context, all of my amendments speak to the same issue, extending the preventions of coercive control over intimate partners to, throughout the legislation, include those who are seniors, those who are family members, those who through other methods experience coercive control. So again, the partie vert, which is why it's PV, partie variance. It's very simple. This is the simplest style of the motion. And you're right, PV4 is longer and more complete in its attempt, is to add to intimate partner or relative. As you see, it would be replacing line 15 on page 2. Thank you, Mr. Chair.
Thank you, Ms. May. Mr. Housefather.
Thank you very much. I want to thank my dear friend from the Green Party for her amendment. I also listened to those witnesses with a great deal of sympathy, particularly those representing seniors who came to the committee and talked about the vulnerabilities of seniors to other members of their families and others who take advantage of them. But we also heard from police that they need time to get their hands around and get a handle on the type of intimate partner violence that the bill was originally constructed for. So what G35 later in the package does with respect to adding to the concept of coercive control, it says that at 5 years there will be a review, and one of the things that obligatorily must happen in that review is a review of broadening the concept of coercive control to others who might indeed be impacted, such as family members. So I think given that there's a 2-year coming into force for the provisions on coercive control, precisely because people need to be trained and need to have the opportunity for police to learn how to deal with those provisions, we're, I think, better off adding a second round where we will then, after we've had a few years to deal with intimate partner coercive control, then get a handle on how to draft coercive control for other types of people, knowing that this has now happened right in other jurisdictions where in the state of Victoria in Australia, in Ireland, people have started with one and then moved on to the other. So I appreciate very much my colleagues' amendments, and I think at least you'll see G35 as a step forward in terms of making sure this concept is included in the bill.
Thank you. Ms. Khalid?
Thank you, Chair. Just really quickly, I want to echo the voice of Mr. Housefather in that, I've been working on this issue since 2018, and what we have heard from communities, it needs to be nuanced. When we're talking about coercive control versus one group of people and another, I think that our laws need to be a little bit more nuanced, and just adding that in within this legislation is not going to do justice to what Ms. May is trying to achieve, and so I can't support this amendment. Thank you.
Thank you. Okay, no other speakers. Shall PV1 carry? Oh, I'm sorry, Ms. Gazan.
I just have a question on that, because we know with family violence, it impacts all family members, like, for example, children. And sometimes children are used in coercive control to control a partner. Like, I know we're talking about seniors, but I'm wondering how you can protect a spouse that's experiencing intimate partner violence if you don't look at the whole family and how it affects the partner. Like, for example, gaslighting kids in custody battles, for example. Yeah, thanks.
Ms. Khalid, yeah.
Thank you. I think that there's a difference between being a victim and having the support around that victimhood, as opposed to the context of what it is that you're experiencing and who is part of that experience. What this bill, I think, is doing is providing support for the victims specifically, and then leveraging, who can provide experience for outlining what the individual criminal code violations are. And I think that there does need to be a distinction between the two. So that's why I think that there needs to be a little bit more thought and perhaps a little bit more broader consultation around who else can be a part of the coercive control family, if you may.
Okay, thank you. Shall PV1 carry? No. Okay, defeated. Okay, shall Clause 2 carry? Yes. Clause 2 carries. Okay, as amended. Okay, shall Clause 3 carry?
Yes.
Yes, perfect. Carried. Okay. All right. So new clause 3.1, so we're into G2, which is, who's speaking to that? Ms. Latanzio, okay.
So, Mr. Chair, G2 would add more clarity to the new clause in Bill C-16, clarifying that non-disclosure agreements may not prevent or restrict a person from discussing information about the commission of an offense to a police officer.
Thank you. Anybody else? Okay. All right, shall G2 carry? Carried. Okay, the next amendment proposed is CPC 1, which I have reviewed, and I am reviewing, it's out of scope. For what reason? I'm about to get to that. It purports to amend something that's not part of what we're doing in this bill, is the bottom line. I can read you the ruling if you want.
Make submissions?
Yeah,
on that?
I'd be happy to hear from you, Mr. Brock.
Sure. Thank you, Chair, for telegraphing your intent. I take exception to what I anticipate your ruling will be, because what we have heard from the Justice Minister on at least one occasion, and also when he attended at Status of Women, I had the opportunity of questioning him on both occasions with respect as to why the government chose not to reinstate all the mandatory minimum penalties that were removed under C5. And I said that with a view of being cognizant of the minister's approach in Bill C-16 by providing the safety valve. He essentially has indicated on numerous occasions, inside and outside the House, that the intent was to allow all those mandatory minimum penalty offenses that had been ruled unconstitutional by various courts, including the Supreme Court of Canada, to be resurrected and to reinstate mandatory minimum penalties, and to allow a sentencing judge or trial judge to determine whether or not they can deviate from the mandatory minimum penalty if there's a finding that the application of a mandatory minimum penalty would constitute cruel and unusual punishment. So if the government is prepared to bring back mandatory minimum penalties that had been ruled unconstitutional, my view was, and I did not receive a cogent answer, a proper answer from the minister on 2 occasions to this point. Why did he specifically exclude C5 offenses? And I also bring to his attention, I bring to this committee's attention, that literally within 30 days after the passage of Bill C5, the Supreme Court of Canada ruled on 2 gun offenses. It was the Hills and Hillback decision going back to January the 27th, 2023. And this is after C5 received royal assent. In the Hills decision, they held that the mandatory minimum penalty of 4 years of intentionally discharging a firearm violated Section 12 of the Charter, but in Hillback, in a 7-2 judgment, ruled that the 4 and 5 year mandatory minimum penalties for robbery with a firearm and robbery with a restricted or prohibited firearm did not violate Section 12 of the Charter, but it was moot given the passage of Bill C5. I brought that issue and that particular case in the House to the attention of the then Justice Minister, trying to remember his name now, David Lametti. David Lametti, who completely disagreed with me and in sheer arrogance told me to reread the decision. Well, I had the decision. I've reread it numerous times, And that Supreme Court of Canada upheld a mandatory minimum penalty that this government chose to include in C5. The language surrounding C5 during the debate was, these are all offenses that routinely are ruled unconstitutional by various courts, and it was also designed to address the over-incarceration of marginalized members of Canadian society, including Black Canadians, including Indigenous Canadians and Indigenous youth, given the over-incarceration rate of both of those classes of individuals. I have been tracking the incarceration rate of those classes of individuals since Royal Assent and Bill C5, and Bill C5 has been an abject failure because the incarceration rate has not decreased. If anything, it has increased. So I don't view this being completely out of scope, with all due respect, Mr. Chair. If the government is prepared to resurrect mandatory minimum penalties that have been ruled unconstitutional, and if they telegraph that type of language to the creation of Bill C5, I think is completely relevant to this discussion, that those offenses, all 6 Controlled Drugs and Substance Act offenses and all 14 offenses under the Criminal Code of Canada, be reintroduced for consideration by a particular sentencing judge as to whether or not a safety valve would be appropriate in those circumstances.
Okay, thank you, Mr. Brock. I'm now going to give my ruling. You know, when I was a young lawyer, I once appeared before a judge, and she dismissed my motion. I said, Your Honor, I usually like to argue my case before I lose it, so that's why I wanted to hear from you, which I think is fair. So I'm going to explain why I'm ruling this out of scope, which will help because this is not the last time we're going to encounter this issue today. So let me just read as follows. Bill C-16 amends the Criminal Code to create new offenses and expand existing ones, most notably criminalizing coercive and controlling conduct, strengthening sexual and child protection offenses, reclassifying certain killings as first-degree murder, broadening evidentiary and victim protection rules for those offenses, and reforming sentencing, delay, and restorative justice frameworks. The amendment seeks to amend subsection 85(3) of the Criminal Code. As the House of Commons Procedure and Practice 4th edition states in section 16.75, an amendment is generally inadmissible if it proposes to amend a statute that is not before the committee or a section of the parent act unless the latter is specifically amended by a clause of the bill. Subsection 85 of the Act is not being amended by Bill C-16. Furthermore, the amendment seeks to create a new offense for offenses that are not directly connected to the scope of this bill. It is therefore my opinion that the amendment is inadmissible. So that is my ruling. Okay, you're free to challenge. Okay, Mr. Clerk.
Thank you, Mr. Chair. On the motion, shall the chair's ruling be sustained? Madame Latanzio?
Yes.
Monsieur Housefather?
Yes.
Madame Dillon? Yes. Mr. Chang? Yes. Madame Khalid?
Yes.
Madame Gadu?
Yes.
Mr. Brock? No. Mr. Baber? No. Mr. Gill? No. Mr. Lawton? No. Mr. Fortin? No. Okay, 6-4, sustained.
Okay, ruling sustained. Okay, so now we move to new CPC 2, which I have also reviewed and considered and ruling that it is out of scope as well. For
officials?
not until I finish speaking, Mr. Baber. So for similar, if not identical reasons from the ruling I just made, I'm ruling that CPC 2 is out of scope. Mr. Baber, I will hear from you, but I don't want to hear arguments on appeal because I've already made my ruling.
I'd like to pose a question to our officials.
Hold on, is the question about my ruling? Because if it is, I'm not allowing it.
Well,
because the ruling's been made. You have the right to challenge
understand,
it.
but
No. Is it a yes or no question, Mr. Baber? Is your question to the officials about the ruling I just made, yes or no?
it may be interpreted as related. Now,
So that's a yes, so
I
I'm not
sought
going
to
to allow the
bring
question.
that clarification before you made your ruling.
I've made my ruling, Mr. Baber. Your procedural right, so you can challenge my ruling, or we can move on. It's entirely up to you.
Mr. Chair, I wanted to seek the clarification, I'd like to genuinely, in good faith, to seek from the officials before you made your ruling.
I know exactly
I
what
have
you're
a
trying to
criminal-
do, Mr.
I have a
Barber, but
criminal law
I have already
question.
made my ruling. So it's too late. So your only option is to challenge my ruling. Do you wish to challenge my ruling?
Yes. Okay, yes.
Okay, all right. Mr. Clerk.
On the motion, shall the chair's ruling be sustained? Madame Latenzio?
Yes.
Monsieur Osfather?
Yes.
Madame Dillon? Mr. Chang?
Yes.
Madame Khalid?
Yes.
Madame Gladu? Mr. Brock?
No.
Mr. Baber?
No.
Sir Gill?
No.
Mr. Lawton?
No.
Mr. Fortin? Okay, sustained.
Okay, ruling upheld. Okay, so which takes us to CPC 3, which I'm afraid I'm also ruling out of scope for reasons identical to the two previous rulings.
Point of order.
Yes, Mr. Lawton?
So I understand where you're going with this, Chair. I just want to refer to, because it is very germane to this, what the minister himself said on C-16 about the intent of the bill. And he said, the bill, this is a direct quote from his testimony here, the bill takes significant steps to restore mandatory minimum penalties for a wide variety of crimes where a mandatory minimum penalty has either been struck down or maintains its place within the criminal code today, but carries with it constitutional vulnerability as a result of the treatment by the court of mandatory minimums. So keeping with the minister's stated intent of the bill, this is entirely within the scope of Bill C-16 because it seeks to preserve mandatory minimums in a way that is constitutionally valid.
Rulings by their nature are required because there's differing opinions on whether it's admissible or not. And I appreciate your comments, and I appreciate you referring to the comments of the minister. It doesn't change my ruling.
Disagreeing with the Attorney General of
Mr.
Canada.
Baber, yes?
Yes. Perhaps.
Are you challenging my ruling? Are you
Wait a
challenging my
second.
ruling?
Wait a minute. I don't want to challenge your
Well,
ruling.
not on that statement.
All
I
right,
don't.
all right.
Okay, I
People-
have a point of
people,
I
let's-
have a point of privilege now.
Mr. Baber, what's your point of privilege?
I'm a member of the Justice Committee studying a bill. I have a question, a genuine question for the officials on criminal law before we proceed. Will you not allow me to pose my question?
No.
Thank you.
Okay, all right, so we're moving on to CPC 4. CPC 3 is
out of
ruled
order.
out of, yeah.
Out of order, okay.
Challenge.
Okay, challenge. Mr. Clerk?
Sure. Sorry about that.
Sorry, Steve.
If I may, I've already heard your ruling before, but I have not been able to make any submissions. I'm not asking for submissions. I just want to understand
I'm
clarification.
not asking for submissions either, just so we're clear.
Okay.
Okay.
Point of clarification.
So on the, shall the chair's ruling be sustained? Madame Latenzio?
Yes.
Monsieur Osfather?
Oui.
Madame Dillon?
Yes.
Mr. Chang?
Yes.
Madame Khalid?
Yes.
Madame Gladu?
Oui.
Mr. Brock?
No.
Mr. Baber?
No.
Mr. Gill?
No.
Mr. Lawton?
No.
Mr. Fortin?
No.
6-5 sustained.
Okay, ruling sustained, that's CPC 3, out of scope. We're now on to CPC 4, which I'm also ruling out of scope for the same reasons as the previous proposed amendment.
Raise a point of clarification.
You can, Mr. Baber.
Thank you. I'd like the officials to.
No, with me. Are you asking the officials,
To clarify something on the legislation.
is it to do with the ruling or whether this is in scope or not?
Maybe not.
Well,
I don't know.
you're the only one who knows that. You're the only one who knows the answer to that question, Mr. Baber, so.
I cannot-
Perhaps you
Yeah.
can enlighten us.
I don't think that any of this is funny.
There's nothing funny about any of
Nothing
this.
is funny about
Mr.
this.
Baber,
I'm seeking
Mr.
clarification
Baber,
from the officials.
Nothing is funny
Yeah.
about any of this. I asked you a very simple question, and you gave me a vague answer, so I'm asking for clarification. You said it might. You're the only one who has that information.
It depends on the answer.
So that, no, it doesn't work that way. Okay. Do you have a submission to make on my ruling? I'll give you that much.
Yes, I appreciate that. So,
Okay.
so my submission would involve a question to the officials.
No. The ruling's already been made, Mr. Baber.
You have not given me an opportunity to speak or clarify in advance of your ruling. You've heard from Mr. Brock. I appreciate
I
that.
said at the beginning,
Yeah.
on the first one, that we're going to be doing this more than once, because I've gone through these proposed
Well, then
amendments.
maybe- well, maybe I
And
get to
the
go.
rulings are all for the same reasons. In deference to Mr. Brock and your entire team, I thought it would be appropriate to hear from him. I'm not going to sit here and listen to arguments over and over again on the same issue. The ruling's been made. If you want to challenge the ruling, you're entitled to do so. Okay, all right. So CPC 4 is out of scope. Challenge, okay.
On the motion, shall the chair's ruling be sustained? Madame Latenzio?
Yes.
Monsieur Osfather? Oui. Madame Dillon? Yes. Mr. Chang? Madame Khalid?
Yes.
Madame Gladu?
Yes.
Mr. Brock?
No.
Mr. Baber?
No?
Mr. Gill?
No.
Mr. Lawton?
No.
Mr. Fortin?
No.
Sustained, 6-5.
Okay, thank you. Okay, new CPC 5, also ruling is out of scope for reasons that I've already provided earlier.
Challenge.
Challenge, okay. Mr. Clerk?
On the motion, shall the chair's ruling be sustained? Madame Latenzio?
Yes.
Monsieur Osfather?
Oui.
Madame Dillon?
Yes.
Mr. Chang?
Yes.
Madame Khalid?
Yes.
Madame Gladu?
Oui.
Mr. Brock?
Really interesting how the tone of this Justice Committee has changed within 2 days with a majority. Just ramming through this piece of
It's a yes or-
legislation.
it's a yes or
The
no
answer
vote,
is
Mr. Brown.
absolutely no.
Thank you, thank you.
Mr. Baber?
No?
Mr. Gill? No. Mr. Lawton?
No.
Mr. Fortin?
No.
Sustained, 6-5.
Okay, thank you. Okay, we've got a few more of these. CPC 6, I'm also ruling for the same reasons that it's out of scope.
Challenge.
Thank you. Mr. Clerk?
On the motion, shall the chair's ruling be sustained on CPC 6? Madame Latenzio? Yes. Monsieur Osfather?
Yes.
Madame Dillon?
Yes.
Mr. Chang?
Yes.
Madame Khalid?
Yes.
Madame Gladu?
Yes.
Mr. Brock?
No.
Mr. Baber?
It's unthinkable that I'm unable to ask.
yes or
a
no
question
question,
from the
Mr. Baber.
officials. No.
Thank you. Mr. Gill?
No.
Mr. Lawton?
No.
Monsieur Fortin?
No.
Sustained, 6-5.
Okay. Okay, so that was CP 6, right? That was 6. Okay, so now CPC 7. I'm also ruling out of scope.
Challenge.
Mr. Clerk?
On the motion, shall the chair's ruling be sustained? Madame Latenzio?
Yes.
Monsieur Osfather?
Yes.
Madame Dillon?
Yes.
Mr. Chang?
Yes.
Madame Khalid?
Yes.
Madame Gladu?
Yes.
Mr. Brock?
No.
Mr. Baber?
No.
Mr. Gill?
No.
Mr. Lawton?
No.
Mr. Fortin?
No.
Sustained, 6-5.
That was 7, right? Okay. And CPC 8 is also out of scope. It's identical to CPC 6.
Challenge, Chair.
Mr. Lawton?
If I may on this, I cited earlier the comments from the minister on this. May I ask whether you considered that in making your decision? Because like what's happening now is that you are making rulings that are attempt to do what the minister claims this bill was supposed to do, which is restore mandatory minimums to the criminal code. You're making that impossible by not even allowing debate or a vote on these. And it would be helpful to know what you relied on in reaching this series of out-of-scope declarations.
I read the amendment, I read the rules, I considered all information which I considered relevant, including listening to you and Mr. Brock today, Mr. Lawton. I think
Did you rely upon the
I
minister?
think that's encompassed in Mr. Lawton's comments, but thank you.
Is that a yes or a no?
Yeah,
Chair?
yeah. Anyway, I've made my ruling, so.
Chair, did you take into consideration?
I've made my, I just
Minister of
answered that
Justice
question. I
comments.
just answered that question, Mr. Brock, in response to Mr. Lawton's question, so yes. Okay, so CPC 8. Actually, CPC can't not be 8 moved at all because it's identical to CPC 6, which takes us to CPC 9, which is also identical to CPC 5, which is also ruled out of scope and already been ruled on. So now we're on, yeah. Okay, so We're into clause 4. We're on PV2. Wait, did we vote on clause 3?
No, we already did. These are
Thank you, Mr. Chair. Mr. Chair?
All right. Yeah, PV2. Yeah, Ms. May?
Thank you, Mr. Chair. I hope this lightens the mood
Point
and
of order.
makes your heart glad. Sorry?
Sorry, I had heard a point of order.
I feel we breezed past clause 3.1.
No, we voted on clause 3. All of these proposed amendments that we just went through were new clauses, so there was, because there were rules.
But
out of
was
scope.
G2 not adopted as part of clause 3.1? Did G2 not establish the creation of clause 3.1?
G2 was part of clause. Yeah, hold on one second, Mr. Watt. G2 was part of clause 3, wasn't it?
It's fine because the amendment creates the new clause, but
Yeah.
you don't need to vote on
Okay.
it.
Yeah, so the amendment itself created the new clause, so we don't need to vote on it again, but thank you. Okay, sorry, Ms. May, you had the floor?
No, it's right. Thank you, Mr. Chair. I'm in an awkward position here, so I'm going to look to you for guidance. Now that Mr. Housefather has again drawn my attention to G35, I've been considering it before showing up here today, but I am encouraged to see the government effort, and as Mr. Housefather has put it, that to study it and consider. I know I have a lot of amendments to one point only, 11 amendments. Under the terms of the motion passed by this committee, not to belabor the point, I have no rights here such as to suggest I'd like to withdraw my amendments, knowing that G35 may actually solve the problem and mean that the voices of so many wonderful groups, the seniors organizations, the Canadian Network for the Prevention of Elder Abuse, and so on, have been heard. If I had the right, I would now say I would like to withdraw my amendments to save the committee time, because I can confidently, I think, not assume, but confidently expect that all my amendments will be defeated. And there's no point in taking the committee's time for that, now that I'm particularly encouraged by G35. So, Mr. Chair, they are deemed moved. I'm not allowed to do anything about them at this stage.
No, but I believe if I get unanimous consent from the voting members of the committee, it can be withdrawn.
That's correct.
Do I have-
All of my amendments, I request the committee to
On
consider
all,
withdrawing
on
them.
all of, okay.
Yes, they all speak to the same point.
Is everybody clear on that? Do I have unanimous consent from the committee to have all of the Green Party proposed amendments withdrawn? Okay, all right, thank you. Thank you, Ms. May. Okay, shall clause 4 carry? Yes. Carried. Shall clause 5 carry? Carried. Okay, so we're into clause 6, and we'll go to G3, which is
I'm going to speak to it, Mr.
Ms.
Chair.
Latanzio.
Okay, so this motion would amend Bill C-16's, oh, you are? Okay, go ahead.
Sorry, Ms. Dillon, okay?
Okay, sorry.
It's okay, thank you. So it's to amend by replacing line 11 on page 3 with sexual organs includes genital organs. So, yeah,
Thank you.
everything okay?
Any comments on G3? No? Okay, shall G3 carry? Yes, carried. Okay, shall clause 6 carry? Yes. Carried. Shall clause 7 carry? Yes. Carried. Shall clause 8 carry? Yes. Carried. Shall clause 9 carry? Yes. Carried. Shall clause 10 carry? Yes. Carried. Shall clause 11 carry? Yes. Okay, moving right along. So we're into clause 12, which is NDP2. So, Ms. Gazan, I believe that's,
Thank you. Can I speak to this, Chair?
yes, please.
Okay, perfect, thank you. So this amendment relates to sexually explicit deep fake images, something that's of major concern to women and gender diverse people across Canada. When sexual predators generate sexually explicit images, recognizable individuals, that is an act of violence. When someone creates a sexualized image of you without your consent, where the intent of sexualization is to humiliate and silence you, that is a violation of your safety. As an example of where this bill falls short, we've seen recently on X Twitter has encouraged users to produce sexualized images using its Grok AI tool, including realistic human images of those resembling children and underage girls. As experts have told us, the legislations as it is currently drafted would not capture these offenses, as it does not include the word creation of images, only their distribution. Other countries have been tougher on big tech executives like Elon Musk and banned this platform, but so far, even in this legislation, the government has failed to act to protect the safety of women and children. So I'm urging the government, I'm urging all members of this committee to join me in improving this legislation by refusing to be soft on tech giants like Elon Musk and prohibiting the creation of sexually explicit deepfakes that violate the safety and well-being of women and gender-diverse peoples. And this was also echoed by Child First Canada, even in the new recommendations to prohibit children and young teens to go on social media, that although they're not opposed to having age restriction, it does not deal with the root of the problem, and that is holding big media tech giants responsible for allowing these abuses to occur. Thank you.
Thank you. Anyone else want to make? Mr. Fortin?
Merci, Monsieur le Président.
Thank you, Chair. I think that our colleagues' concern is valid. The problem I see is that production per se is not defined in C16, and this could open the door to abusive interpretation. So what I think, and I'm not the one to decide, but I feel the Minister of Justice should look into the issue, and maybe during a subsequent review, we could introduce a definition of production and add it to the bill. But I share her concern, but as I said, at this point, I would like to vote against. In other NDP amendments, it's the same problem. Production is not defined.
Fortin, anybody else? Mr. Housefather, and then Mr. Lawton.
Mr. Kerr, je veux juste dire que je partage le point de vue de Monsieur Fortin.
I share Mr. Fortin's point of view. The Supreme Court, in English, created private use exception already in many cases. And I think there's going to be a charter problem because the Supreme Court has already defined private use exception, which is not included in the amendment proposed. So I agree that we need to look into that issue in the future. Thank you.
Yeah, I was just hoping to get some clarification from the officials on that point as well. You know, and again, I understand we are, especially in this section of the bill, dealing with reprehensible content. There's no doubt about that. But the law as it stands does distinguish between publication and creation that stays on someone's computer and is never shared with anyone. That is a fairly clear distinction in the law right now, correct? And anything you can now add about why that is the case would be helpful.
Certainly. Thank you for the question. So I'm sure you're all familiar with the Supreme Court of Canada's 2001 Sharp decision. And in that decision, they held that making and possessing fictional child sexual abuse and exploitation material doesn't cause sufficient harm to merit criminalization. And so in order to preserve its constitutionality, they read in a private use exception, and basically that exception exculpates a person who possesses or makes fictional child sexual abuse and exploitation material and keeps that material solely for their own use, unless there's evidence that the accused made the material with intent to distribute it. So I'd like to stress that officials are seized of this matter and are working on it, including with our provincial and territorial partners who enforce the law and can help us gather the evidence that we need to justify a full ban. Thank you very much.
And just to confirm, Ms. Levman, so if someone makes it with the intent to distribute but is arrested under some circumstances before that distribution has happened, that is already captured by the law?
Well, you'd have to prove it through the evidence. You'd have to prove that the person...
But there is already an offense there. assuming it's proved.
Well, the private use exception only applies
Okay.
to somebody who makes it and keeps it for their own use. So the flip side of that is that if that person intended to distribute it, they don't have access to the private use exception, if that makes sense.
Thank you.
Yeah. All right, thanks, Mr. Lawton. Anybody else? No? Okay.
Question.
Sure, go ahead, Ms. Gazan.
I mean, we're talking about child sexual abuse, but what happens then if it's an adult? Somebody takes a picture for their own personal use. What sort of protections do they get? And I bring that question up because that's really what's being brought up by women's organizations, both the distribution, but also the use of deep fakes for any purposes without permission by the victim. So, I really do hope that there's swift action on this because that's really the root of the problem. And the people that are doing it are getting off scot-free, and we're lessening the restraints on big tech giants that are being totally irresponsible around the dissemination of violence against women. So I just want to leave it there. I'm not here often, so I'm going to use this time to defend. Okay, thanks.
Okay, seeing no other hands, so shall NDP 2 carry? Okay, defeated. Shall clause 12 carry? Yes. Shall clause 13 carry? Yes. Okay, so now we're on to CPC 10. Who's Mr. Lawton? Mr. Lawton, okay.
Thank you, Mr. Chair. So this is an amendment that would replace line 30 on page 6 in clause 14 with the following: reasonably be expected to be nude or nearly nude. The main change on this is the addition of nearly nude when we're talking about this sort of material. This was something that came out of the witness testimony we heard. And as I shared when this came up, it actually came out of not a personal experience that I encountered. No one would want to see that, but something that a friend of mine had encountered on social media. And we are seeing with the advancement of technology, these very sophisticated and in some cases quite traumatizing assaults taking place. So it simply just ensures that a small technicality is not excluding something that I think this law intends to capture from its capture. So that's where that came from, and I believe it was actually the NOL that had suggested it originally, and some other stakeholders we consulted were very supportive of this.
Thank you, Mr. Lawton. Ms. Latanzio?
I want to say that I agree with Mr. Lawton as it clarifies the scope of the offence and it aligns with evolving case law and it responds to the needs of the victims. So I agree with you.
Mr. Fortin.
I have the same feeling as I had with the NDP amendment where the term production was not defined. The Bloc Québécois read the amendment proposed by Mr. Lawton. I understand the spirit and I understand the concern. Being almost nude is disturbing. If someone, every time on the beaches we see people who are almost nude in swimsuits, and increasingly swimsuits are really flimsy these days. So what are we targeting when we talk about almost nude? I don't think he's trying to prevent people from moving around in swimsuits, but it's too vague, and this opens the door to a lot of abuse. And it will be difficult for us to support that amendment, even though, once again, I understand my colleagues' concerns.
Thank you, Mr. Fortin. Okay, shall CPC 10 carry? Yes. Okay, carried. Sure, on division, okay. Okay. Shall clause 14 carry as amended? Yes? Carried. So we're into clause 15, which takes us to NDP 3. So Ms. Gazan, back to you.
Well,
Please,
sorry.
yeah.
It really follows the same suggestion as my previous amendment, and it was also submitted by Leaf. Because we want to reiterate the importance of ensuring this legislation not remain soft on big tech giants that are profiting off the endangerment and sexual humiliation of women, gender diverse people, and to include the creation of sexual deepfakes in this offense. Like, you know, we're not really dealing with the problem. We're not dealing with the actual source of and the companies that are disseminating this information or these photographs. Like, they're getting totally off the hook. And there's concern within women's organizations that it's not, the root of it is not being dealt with. So I just reiterate what I said before.
Thank you very much. Anybody else? No? Okay. Shall NDP 3 carry? No. Okay, so CPC 11. Anyone? Mr. Lawton?
Thank you very much. This one, I have to give partial credit for the work on this one to my colleague Michelle Rempel-Garner, who tackled a lot of the issues long before the government did in her bill C-216. This was also something that came about through some testimony we heard from witnesses. It really just adds an escalating penalty for the material at issue here. You know, if we're talking about material that depicts sexual assault, it increases the maximum penalty. So I think it's putting some graduated sentencing in there, which is making this, I think, very serious, as it deserves to be.
Thank you, Mr. Lawton. Ms. Latanzio? Oh, sorry, I thought you had your hand up. Okay. She's in violent agreement. Okay. Nobody else then? Okay. So CPC 11 carry? Yes. Yes. Okay. So we're NDP 4. I'll give you the floor in a moment, Ms. Gazan. So if NDP 4 is adopted, CPC 12 cannot be moved due to a line conflict. So just bear that in mind. Ms. Gazan.
Yes, thank you. Again, similar to my last amendments, this amendment concerns the urgent problem of sexually explicit deepfake images. Legal experts have shared with us that the bill is currently drafted, as it's currently drafted, does not capture all offenses that are taking place on online platforms. This was submitted by NOL. Like X, including the depiction of women and children in contexts where they are not fully nude but are clearly in sexualized positions. That includes being depicted in a sexualized or revealing clothing such as transparent bathing suits or humiliating conditions such as being covered in blood or bruises. These are acts of violence that are meant to humiliate the images that they depict. We cannot leave open loopholes in this legislation that perpetrators can exploit to evade justice. And I urge my colleagues to vote in favor of this amendment to close this loophole. Because I really, in good faith, Mr. Speaker, I don't see any sort of shift happening in terms of protecting victims of this crime unless we are dealing with the very companies that are allowing the dissemination of this material. That was submitted by Noel. Thank you, Mr. Chair.
Thank you.
Point of order.
Yeah, Mr. Lawton.
If I could, Mr. Chair, would you agree that there is a line conflict between NDP 4 and CPC 12? And the reason I say that is because...
So, I don't want to interrupt you. I started by saying there's a line conflict. Yeah.
I was already looking ahead then. My apologies.
Yeah, well, we're on the same page.
Okay.
Here, so, okay.
So I'll speak to it then.
Okay.
I actually have a great deal of appreciation for what Ms. Kazan has tried to do here. I would be inclined to vote no because I feel that CPC 12, which I will be moving right after, achieves the same things but actually goes a bit further, specifically because it has specific capture of artificial intelligence. So that would be the only reason I'm inclined to say no to NDP 4. And if there is an opportunity to, if Ms. Gazan feels that, a sub-amendment on CPC 12 might be necessary, but I think it captures what she's trying to do here and more.
Thank you, Mr. Lawton. Okay, so shall NDP 4 carry? No. Okay. defeated. Okay, which takes us then to CPC 12. Mr. Lawton, I assume that's you then.
Thank you very much. So just very briefly on CPC 12, we're trying to ensure that we don't end up having to come back to the drawing board because this fails to capture the technologies that we're dealing with here. We have to acknowledge the role that artificial intelligence is playing in a lot of the issues we're talking about, deep fakes, deep nudes, as they're referred to. What my amendment does is it specifically references including by means of artificial intelligence software, and that shows an identifiable person who is depicted as nude, as nearly nude, as exposing. It's just making sure we're fully aware of what we're incorporating in here. It isn't just photographs. It also is meeting the technological challenges head on, which are being used increasingly to victimize women and girls, but all people as well.
Okay, thank you, Mr. Lawton. Anybody else? No? Okay, so shall CPC 12 carry? Yes. Yes, carried. Okay. Shall clause 15 carry? As amended. As amended, carried. Shall clause 16 carry? Yes. Okay, so clause 17 takes us to CPC 13. Mr. Baber? Okay.
CPC 13. I think CPC 13, first of all, I'll explain very briefly what it does. It essentially adds the notwithstanding language for child pornography possession offenses under Section 163(1) sub 4 and 4.1, therefore shielding them from the application of Section 7 and 12 of the Charter. Also, this applies Bill C-16 MMPs. I had a very interesting exchange with the Attorney General here a couple of weeks ago, where the Attorney General, as I learned subsequently, discussed it with a reporter in the National Post, that he actually considered this very amendment, that he actually considered invoking the notwithstanding clause in response to the Seneville and Nod decision. As we recall, Seneville and Nod struck down mandatory minimum sentences for access and for possession and access, and in Nod's case, distribution of child pornography. And I had a intellectual exchange with the Attorney General where I put it to him that the reason for Section 33, the reason for the notwithstanding clause was to prevent absurdity. That's how Attorney General Jean Chrétien was able to seal the deal on the Charter. And the example that Jean Chrétien used was what happens if the Supreme Court comes back and says that possession of child pornography, God forbid, is now constitutional by virtue of freedom of expression. That's not what we had in Seneville, but we had a similar decision where essentially now the court, using a reasonable hypothetical, decided that a one-year sentence could be cruel and unusual in the case of Mr. Seneville and Mr. Nod. And what's important is the court did not consider the facts before them to amount to cruel and unusual. The court did not say that you, Mr. Nod, holding 250 videos of children being raped should not qualify you for the mandatory minimum of a 1 year. What instead the court did is it used a reasonable hypothetical of two teenagers sending each other a picture, a case that no Crown would ever prosecute, that no police officer would ever prosecute. And I'd put it to Attorney General Sean Fraser that if he's not going to use the notwithstanding clause on this scenario, where we maintain the 1 year mandatory minimum sentence for child pornography possession and distribution or accessing such materials, then there will never be a scenario where this government will invoke the notwithstanding clause. Thank goodness. I hear my friend from Montreal saying, thank goodness. I wish he would say thank goodness in response to my amendment that looks to protect these children. I wish he'd say thank goodness that this amendment allows this committee to take a necessary crack at this disgusting industry. Of course we weigh the rights of the accused, But can we for a second weigh the rights of the 250 children that were raped in the videos that Nod was holding? The notwithstanding clause were inserted for a reason. I submit that this is the precise reason. I'd now like to go to the officials and seek clarification on something. Let's take the Supreme Court in Centerville. The Supreme Court strikes down the mandatory minimum penalty. We've heard reference to the Attorney General saying that what this bill might do is restore some of those minimums. We heard the deputy leader we heard the member from Winnipeg, the deputy to the government House leader, suggest that Bill C-16 resurrect some of those mandatory minimum penalties. And so I'd like to understand the legal framework from the officials. Do you understand that the mandatory minimum penalty for accessing child pornography or possessing child pornography is now in effect, or has it been struck down by the Supreme Court? And what would hypothetically happen if such case was to be brought to trial next week?
Thank you for the question. So to answer your first question, the current status of the mandatory minimum penalties for accessing and possessing have been struck down, so courts would not be able to apply those mandatory minimum penalties. If Bill C-16 were enacted, because we have the new structured judicial discretion clause that would permit courts to order a penalty below a mandatory minimum penalty, and we also have a for greater certainty clause that would essentially revive any mandatory minimum penalties that were previously struck down that are still on the statute books. The result of those amendments would be that those two MMPs would once again be available to courts.
Ms. Bird, I'm not sure I understood your answer. I understand that there is an attempt by the Liberal government to suggest that because we're giving judges an out to consider every case before them to be cruel and unusual, that would somehow strengthen mandatory minimum penalties. I get it. I'm not sure that would necessarily have the courts deviate from reasonable hypotheticals. But your first answer was the mandatory minimum penalty for accessing child pornography or possessing child pornography has been struck down, and therefore it no longer applies. Am I correct?
That's the state of the law right now, yes.
Okay. And so when Attorney General Sean Fraser sat exactly where you're sitting right now and said to us that this bill would resurrect those mandatory minimum penalties, he was wrong.
My understanding would be the same as the minister's, that because we have a clause that would revive, it states that for greater certainty all mandatory minimum penalties in federal statutes are once again in effect. And we have a new structured judicial discretion clause that would provide that courts can consider whether or not a mandatory minimum penalty would result in cruel and unusual punishment for the offender before the court without resorting to reasonable hypotheticals. Our view is that, yes, that would mean that those MMPs are once again available.
I apologize, Ms. Bird. You said two different things in your answer. If it's been struck down and it's no longer applicable, just because a court would be free to disregard, perhaps for other offenses that have not been struck out, you'd be able to do that. Mr. Taylor, sounds like you might have something to say.
Only just to maybe thank you for
clarify,
the question.
please.
Yeah, just to try to kind of build on what Ms. Bird had said. Because those MMPs that we're talking about and other MMPs that have been found unconstitutional by the courts but haven't been removed from the criminal code, so they're still on the statute book. They're not enforceable, as Ms. Bird has said. Okay. With the enactment of C-16, because of rules of stare decisis, when and if Parliament enacted C-16, there would be material changes in the state of the criminal law. And one of those material changes, as Ms. Bird has described, is that courts would be able to depart from the imposition of a mandatory minimum penalty where it would result in a grossly disproportionate outcome for the particular offender before the court.
But again, I apologize, Mr. Taylor. What you're saying is that courts may refer essentially to the existing MMP, even though by virtue of stare decisis, it's no longer binding. But now you're saying the court will have potentially some sort of plank to look at and say, well, we previously had an MMP, and then it was struck down, and I might choose to guide myself by virtue of the previous MMP. But I'm not bound by the MMP, correct? In other words, before the Centerville decision, the court was bound by the MMP, subject to a charter application that would potentially find the penalty to be cruel and unusual. You're saying, please, maybe in a yes or a no, this bill does not restore the MMP. It does not make it binding on the court.
It would restore the MMP because of the rules of stare decisis.
So the 1 year MMP so according to your view, the 1 year MMP for access or possession of child pornography will be restored if C-16 is passed by Parliament?
Correct.
Okay. Well, first of all, if you are correct, then every single CPC amendment that was brought and ruled by the chair out of scope would be in order. Because what those amendments sought to do was to clarify the precise uncertainty that we're having right now. I'm not sure I agree with you. I think that we're living in a vacuum right now.
Point of order, Mr. Chair?
Thank you, Ms. Khaled. Yes?
I'm just wondering about the relevance of what Mr. Baber is talking about, if it's relevant to exactly the amendment that we're talking about.
It's a fair point, Ms. Khaled. Mr. Barber? I mean, you've got the answer to your question. You don't like it, so you're pursuing. This isn't a cross-examination. The witnesses are here to provide technical answers to questions.
Fine.
It's not. You're not here to argue with them.
I can have a learned discussion with the officials. I actually think that this is an interesting theoretical. This is a discussion that's going to be had. I see my liberal colleagues of this committee are laughing again. Mr. Taylor and I have had
hold on.
Stop it.
Mr. Barber, don't do that again. You have no idea what's going on the other side of the table.
I can see members
You don't know
laughing.
what they're talking about or
Not
what
only
they're
that,
doing.
we're
Mr.
talking about
Barber,
Nobody's
stop
laughing
talking right now, please.
Yeah.
Ask your questions, get your answers. We're not here to have an intellectual debate.
This is a very important debate.
You've got your answer. Move on to your next question, please.
Mr. Chair, this needs to stop. It's happened so many times before. It's intolerable to make accusations. We're all sitting here with straight faces. Everybody is off camera, so the person on camera cannot just make things up and report them to committee
Point of
and to the
privilege.
public. Thank you very much.
Thank you.
No,
say that
no,
my
it
One
doesn't
One person
fly.
at a time,
No.
Mr. Barber. Ms. Dillon, you finished?
Yes.
Thank you. Mr. Barber.
I am free to continue to speak, and I'm free to continue to characterize my friend's behavior on the other side as laughter.
This conversation is turning into a ridiculous discussion.
That's right. So please let me continue.
But you don't. The point is, you're characterizing something based on something you said, which is completely out of line. I agree with Ms. Dillon. Ask your questions to the witnesses. Let's move on.
Okay. Stare decisis means we have to abide by the court above in the previous decision. So here we would be bound by Centerville. If we have an arrest next week and a trial on a similar charge, the court would not say that it's bound. If I understand you correctly, the court would not say that it's bound because of stare decisis, but it would say it's instructive for now, it's instructive for us to avail ourselves of this new reality that C-16 creates. And we might disagree. I understand the intent of the safety valve. The intent of the safety valve is to say, you no longer need to worry about being subjected to the MMP because you have a side door. You can escape the MMP using the safety valve. I get it. But that in and of itself does not restore the court being compelled by the section that was previously struck down. Correct, Mr. Taylor?
So thank you for the question. And I'll try a different way. Our view is just to kind of pick up on the examples you just gave. Next week, if a court was seized of a child sexual abuse, an exploitation, possession offense, as you said, Mr. Baber, the MMP would not apply in that case because the Supreme Court has found it unconstitutional. It is of no force and effect. It remains in the criminal code, though, so it is on the statute book. When and if C-16 were to receive royal assent and come into force, the law would change in respect of the way mandatory minimum penalties could be interpreted and applied by the courts. And so because and Ms. Burt talked about the for greater certainty clause. Because the law is different at that point, courts would not be bound by the previous decisions that bound them with respect to MMPs. They would be required to impose the MMPs that were previously unavailable to them because of previous court decisions. If an offender, because fundamentally the escape clause is about sentencing at this point, if the offender was of the view that the mandatory jail sentence was grossly disproportionate, not from a constitutional perspective, but from the escape clause perspective and its application, they would make those submissions at sentencing stage. And it would then be for the prosecutor to make their own submissions and ultimately for the court to decide whether or not that MMP would apply or would not apply. And one, I guess, final point I might offer, and you rightly pointed out, in many of these cases, the MMP is not really at issue for the purposes of sentencing for the specific offender. As you pointed out in the Senville decision, the sentence imposed was in excess of the mandatory minimum penalty. And for many of the other MMPs that have been found unconstitutional, as I think you know, they have been found unconstitutional, not because of the specific offender before the courts, but because of the reasonable hypothetical situations.
Mr. Taylor, Nod indeed received 9 months for possession and access. So that was below the mandatory minimum. The reason I'm concerned is that the safety valve instructs the court to look at the individual circumstances before the court, right? Whereas the stare decisis striking of the MMP has nothing to do with the individual circumstances, but has to do with the entire statute as it is on the books. And so I appreciate your optimism. I think that this will take many, many years of litigation to determine this question.
Point of order, Mr. Chair, on
yes.
relevance.
I sensed he was just wrapping up.
Sorry, we're studying. I'm asking questions about the safety valve, which is the key piece of this legislation. Not only do you have a lot of latitude on relevance, I'm talking about the safety valve. I'm having a discussion with the official on the safety valve. I don't understand what the problem is.
Okay, are you getting close to being finished?
Yes.
Okay.
Could you perhaps guide us? We're discussing the safety valve here. Let's say I came to you and I said, I want to do better. I want to make sure that we don't litigate the question that I'm asking right now for the next 10 years, maybe more. What would you recommend? Would you?
Sorry, Mr. Faber, through you, Mr. Chair, is the question, the concern around whether or not if C-16 were to be enacted, that there would be debate as to whether the MMPs that were previously found unconstitutional are in fact revived?
Yes.
Sure, I can try to answer that. So I think and maybe this will be repeating a bit of what Mr. Taylor has already said, but the Supreme Court of Canada has made clear that where a court issues a declaration that a law is inconsistent with the Charter, the law becomes inoperative in the jurisdiction to which the court's order applies. And of course, when it's the Supreme Court of Canada, that means that the MMP becomes inoperative across Canada unless or until it is amended or repealed by the legislature. And the declaration of invalidity operates in accordance with the normal rules of stare decisis. The enactment of a general structural judicial discretion clause is a fundamental legal change that affects the application of the previous judgments declaring mandatory minimums unconstitutional. Because MMPs could no longer apply in circumstances that would violate the Charter by virtue of this new clause, the basis for the previous findings of unconstitutionality have been removed. So in other words, the decisions that made the MMP inoperative, decisions like Senneville, would no longer apply. So I think that's how we would see this sort of playing out.
Okay. So we have a real opportunity here with my amendment. This is an amendment that the Attorney General himself said that he considered. Effectively, what the Liberal government would be telling all Canadians is if we will not safeguard the mandatory minimum penalty for access and possession of child pornography, a one-year sentence, then it might never happen again. I plead with this committee to let's take a serious bite out of this industry by making sure that deterrence, right? The main principle of sentencing is deterrence, and that is jail time. Thank you.
Thank you, Mr. Barber. I was going to suspend at some point. Would anybody object if we did it right now? All right. All right. I didn't think so. I just wanted to make sure. Okay, we'll suspend for a few minutes. The list is Ms. Latanzio.
Okay, so thank you, Mr. Chair. I just want to be clear. Offenses involving child sexual abuse material are amongst the most serious in the criminal code, and those who commit them must face serious consequences. That is why we've addressed this responsibly in C-16. CPC 13 is not responsible, and let me explain why. The amendment would invoke the notwithstanding clause to bring back mandatory minimum penalties that have already been struck down by the Supreme Court, and this would remove the judicial discretion mechanism proposed in this bill. That is not the right approach. Bill 16 takes a more durable path by restoring mandatory minimum penalties in a way that is consistent with the Charter and aligned with Supreme Court guidance. The notwithstanding clause does not fix the problem. As you know, there's a term of 5 years, and it would only delay it. That's all it does. It is temporary, and it would leave some same constitutional vulnerabilities in place. We should also not create a patchwork by addressing only some offenses, while others remain subject to different rules. This bill gives us the opportunity to get this right, to protect victims and ensure accountability in a way that will stand up in court. And yes, Mr. Baber, C-16 does have mandatory minimums in this bill. For those reasons, I will be opposing your amendment.
Thank you, Ms. Latanzio. Mr. Lawton.
I am very pleased to be supporting Mr. Baber's amendment, which would not only reinstate mandatory minimum sentences for heinous offenses, including the distribution and possession of child sexual abuse and exploitation material, but do it in a way that would protect it from being overturned as it was so absurdly by the Supreme Court in the Senville decision. And contrary to how members of the Liberal government have tried to frame the notwithstanding clause on criminal justice issues in the past, the notwithstanding clause is a part of the Charter of Rights and Freedoms. So using the notwithstanding clause is, by design, a charter-compliant mechanism because it is using a tool provided to legislatures, including the federal parliament, to preserve something that Canadians want, Canadians deserve, and victims want, which are not just in these offenses, but in a broader set of offenses, very strong signals from the government, from Parliament, which is accountable to the people, that there should be, just as we have maximum sentences in law, minimum sentences when something is so heinous. We need to have a safeguard against an overly lenient sentence. And in the Senville decision, which, by the way, triggered a robust discussion at this committee, my Conservative colleagues and I moved an amendment to denounce in the strongest possible terms the idea that some sentence of, again, a paltry 1 year even for these offenses could ever be seen as cruel and unusual punishment. The catalyst for the Senville decision was a pair of cases in which the trial judge went below mandatory minimum sentences, proving that judicial leniency is a problem. And this has come up in the past before. This is not an issue that started with the Senville decision. And I'm actually very glad that even Liberal members of Parliament have recognized this. And this is from the debate on Bill C-75 a couple of years back. Quote, "I do not think Canadians look at the decisions that judges have made and think that criminals are getting an adequate punishment for the crime. Well, not every single crime is identical, and I am not opposed to judges having some leeway. It looks to me that the leeway is so big that in many cases we are coming to the minimum sentence instead of something that is more standard." Now, that was from Liberal Member of Parliament Marilyn Gladu. And I think she was actually very accurate in denouncing how judicial leeway is sometimes resulting in subpar decisions. We also had a comment from, again, Liberal MP Marilyn Gladu back in November. The Liberal failure of this was put on full display. The Liberals had Bill C-5, which took away mandatory minimums and put house arrest in place. That made things even worse. So we have recognition from MPs of multiple parties that the Liberals have failed to send serious signals and messages with their criminal justice reforms over the past several years. And I think on something like this, we should be able to band together representatives from all parties and say that there is no tolerance for this type of leniency that would argue a sentence of even just 1 year, which I think even then is too low, is cruel and unusual punishment for someone trafficking in child sexual abuse and exploitation material. So this is a mechanism that Mr. Baber has proposed in his amendment that I think is a very strong one. It is a very important one, and it is in line with what Canadians would expect, which is to not have people that have committed heinous and unthinkable acts sent off with 90-day sentences, 9 months conditional sentences, something that just flies in the face of what truly standing up for victims would look like in the justice system.
Thank you, Mr. Lawton. Mr. Housefather.
Thank you, Mr. Chair. I'm speaking because I almost find it sad that so cavalierly, in the middle of an amendment to a bill, we're throwing in the use of the notwithstanding clause. This is a clause, I will remind everyone, that has not ever been used by the Parliament of Canada in the 44 years since the Canadian Charter of Rights and Freedoms came into effect. This is a clause. The Canadian Charter is different, Mr. Chair, than other charters. The Canadian Charter has Section 1. So for those listening, it subjects rights to reasonable limits. Some rights under the Canadian Charter are not impacted by the notwithstanding clause. The notwithstanding clause cannot be used for certain rights in the Canadian Charter, and we have not had a catastrophe in 44 years as a result. There are other rights that are subject to the notwithstanding clause, but they're also subject to reasonable limits that the Parliament of Canada may impose on those rights. It's not like the United States, where if a right is infringed under the Bill of Rights, the court strikes it down. You have here Section 1 that protects those rights. So what we would be saying is, we believe a right will be infringed. We believe we're not doing it in a reasonable way, so we're going to invoke a nuclear option. A responsible legislator will look at a court decision and will determine, as this Bill C-16 does, how do you get around the Senneville decision? What do you do to ensure that minimum mandatory penalties are not struck down based on reasonable hypotheticals? And this bill formulates a way to avoid the use of the notwithstanding clause. Mr. Baber referred to a former Prime Minister, Jean Chrétien. Jean Chrétien was Prime Minister of Canada for almost 10 years. He never proposed to the Parliament of Canada to invoke the notwithstanding clause. Let me refer to another former Prime Minister, Brian Mulroney. Brian Mulroney said that the Charter was not worth the paper it was written on because of the notwithstanding clause. He firmly opposed throughout the years that he was leader of the Conservative Party and thereafter ever using the notwithstanding clause, because he understood that you don't override fundamental rights in an unreasonable way. But yet, time after time after time, since I've been back on this Justice Committee, I don't remember between 2015, Ms. Khaled will remember, we were sat on the Justice Committee for 4 years. I don't remember any Conservative member between 2015 and 2019 at the Justice Committee proposing that we should invoke the notwithstanding clause in any time. But since I've been here on this committee in the last several months, I've heard over and over and over again a demand that we use the notwithstanding clause on literally everything. And I have heard that you brought forward, sorry, I shouldn't be responding, Mr. Chair. The Conservatives brought forward a motion to say that we should invoke the notwithstanding clause on Senneville. The notwithstanding clause is not necessary in this case. The government is proposing and Parliament is evaluating, this committee is evaluating a different type of solution. And because we all agree that we are disturbed and find unacceptable the decision in Senneville where a minimum mandatory penalty was struck down based on a reasonable hypothetical that didn't tie whatsoever to the people that were the subject of the case, and now that won't be the case anymore. So again, I would wish that all of us would understand the very real impact. If you agree with the notwithstanding clause in one instance, then you cannot argue against it on other instances where it may be used to marginalize you. And having seen how the notwithstanding clause has been used preemptively, arbitrarily, I certainly do not support the Parliament of Canada using the notwithstanding clause at all. And I certainly don't think that the appropriate way to do it is to just throw it into an amendment to a bill like this. For me, this is a fundamental thing. I think that rights are sacrosanct. I think that reasonable limits under Section 1 are sufficient, and I certainly don't agree with using the notwithstanding clause, and certainly not in this way. Thank you, Mr. Chair.
Thanks, Mr. Housefather. Mr. Brock.
With all due respect to my colleague, Mr. Housefather, I could not disagree more with his analysis. It's one thing for the Liberal Party of Canada to stand on their soapbox and claim that they're the party of the Charter, yet completely dismiss the utility and application of Section 33, the notwithstanding clause. Let us not forget the Charter would not be in existence but for Section 33. That is a fact. What we're dealing with here is not a simple willy-nilly application of the notwithstanding clause. It reflects the abhorrence that I would think that every parliamentarian should have with respect to child sexual abuse material. And I want to comment on my colleague, Mr. Lawton's intervention when he spoke briefly about the sentencing judges in the Senneville case, who essentially, I think was Mr. Lawton's comments, undercut the mandatory minimum penalty, but he didn't provide specifics. So I've got the actual decision before me, and I want to remind all of my colleagues here as to what the nature of the collection was for both Senneville and Nod. Senneville admitted to possessing 475 files, including 317 images of children. Of those images, 90% were of young girls between the ages of 3 and 6 years of age, having sexual relations with adults and minors. The sexual relations depicted involved penetration and sodomy. He admitted he had possessed this filth for over a year.
I'm sorry, you don't have rights to make a point of order.
Okay, well, I'll just say that because this is live, it might be triggering for people that have experienced this violence, and maybe we should do a warning for people online.
Thank you, Ms.
who
Gazan.
this
but
might be triggering.
Technically, you're only
Thank you. I
able to speak when you're
apologize.
introducing.
I'm just
but
concerned.
Thank you.
Thanks.
Notwithstanding, Senneville pled guilty, cooperated with the authorities, had no previous criminal record, no outstanding charges. The sentencing judge, and this reflects the problem that we have with lack of consistency across this country at all levels of court in every province and territory when it comes to the appropriate sentencing provisions for this type of filth. The judge imposed a sentence on Senneville on the possession count of 90 days imprisonment. Get this, not to be served consecutively, to be served intermittently. A weekend sentence for possessing this vile filth. On the count of accessing, another 90-day sentence of imprisonment to be served intermittently, and the two sentences to be served concurrently. So this animal got the benefit of a weekend sentence for this filth, followed by 2 years of probation. It is no small wonder that the Crown of jurisdiction decided to appeal. Now, we all know that the Supreme Court of Canada issued a decision which found that the possession and accessing penalties of 1 year were contrary to Section 12. It was a 5-4 split. That dissenting opinion was shared by Chief Justice Wagner, Cote, Rowe, and O'Bonsawin. And I want to read into the record various passages of that dissent. Child pornography has unquestionably become a scourge both nationally and internationally. It destroys countless innocent lives. Each pornographic photograph, video, or audio recording that involves a child is an act of exploitation that will leave the child with deep and lasting scars. Whether it depicts real or fictional children, child pornography normalizes the exploitation of minors and trivializes their objectification. By promoting the decimation and acceptance of sexualized representations of children, the consumption of child pornography in all its forms encourages attitudes and behavior that lead to irreversible harm. The message sent by this court's decision in Friesen could not be any clearer. The sentencing process must convey the profound wrongfulness and harmfulness of offenses against children. And in Shepherd, again from the Supreme Court of Canada, the censure of society and the law must be reflected consistently and rigorously in the sentences imposed on offenders who are guilty of sexual offenses against minors. A fit and proportionate sentence is one that is consistent with the teachings of Friesen and that gives effect to Parliament's intention that sexual offenses against children be punished more heavily. So I wanted to bring that to everyone's attention because, to Mr. Baber's point and the use of hypotheticals, I want to hear from one of the justice officials whether they agree with one of the principles espoused in the dissent that talked about the use of hypotheticals. And I'll quote this passage, and I'd like to know what the position of the Department of Justice is. When a constitutional challenge under Section 12 is based on a hypothetical scenario, as here, the hypothetical scenario chosen must still be reasonable in reference to the Supreme Court's decision in Goltz from 1991. Is that a position, although in a dissenting opinion, is that a position that is shared by Canada's Department of Justice?
Yes, I think the premise that a hypothetical does need to be reasonable is one that we would share. Yes.
Well, we all know that the so-called reasonable, and I use that in air quotes, the reasonable hypothetical used by our learned justices just down the street had absolutely nothing to do remotely similar to the activities of Senneville and Nod. The Supreme Court of Canada, in my opinion, whether it's shared by colleagues at this table or not, this is my opinion, is not reasonable. It was completely remote, had no factual nexus to the offending type of behavior by Senneville and Nod. It involved two young men, one of whom took an intimate image of his girlfriend and shared that image with the other friend. And in those circumstances, the Supreme Court of Canada, in the majority opinion, felt that the application of a one-year MMP would be contrary to Section 12. As a former justice participant, I couldn't agree more. I want to ask the justice officials, during the consultation phase of the creation of this particular bill, this is something that has been a concern of mine for some time. Did you get any feedback from any active police services, any police associations, or Crown Attorney associations, and/or provincial or territorial attorney generals with respect to the built-in discretion that currently exists between policing, between the Crown's office, such that if this particular scenario were ever to find itself in a real-life situation, I can't imagine any Crown in this country in those circumstances agreeing to take a criminal charge initiated by a police service and proceeding by indictment in those unique circumstances and ask for a 1-year mandatory minimum penalty. So to the department officials, the reason I say that, if this is not only my opinion, this is the opinion of several Supreme Court justices, including the famous retired, learned, the Dean of Criminal Law, in my view, the retired Supreme Court Justice Michael Moldaver, who often opined in many of his decisions about the built-in residual discretion that already exists so that these crazy, whacked-out hypotheticals used by judges across this country never see the light of day. Did you receive that input, justice officials?
Thank you for the question. We'd be happy to provide a list of partners and stakeholders that we had an opportunity to speak with in the development of the legislation. I think we may have provided that previously, but if not, we're happy to do so. Offhand, I cannot remember specifically on Crown associations, Mr. Brock, through you, Mr. Chair, but certainly provincial partners, provincial prosecutors, law enforcement, civil society organizations like the Canadian Civil Liberties Association. We had an opportunity to speak with all of them. The issue of discretion, the built-in discretion that you talk about in terms of police discretion or Crown discretion, to my recollection, was not specifically discussed. But I do recall, and I believe it is the newer decision, and it, albeit at slightly different circumstances, where the court talked about the role of discretion in saving constitutionally invalid provisions, and that it cannot be used as a way of safeguarding against
not the minority.
Yes, yes.
Right.
So, I mean, the examples you give whereby a police officer or prosecutor don't bring a specific case before the courts, in respect of that specific individual, the risks don't arise. But
so, okay, I appreciate that. Sure. Thank you, Mr. Taylor. This is the problem, and this is a glaring omission in Bill C-16. We know that there is a limit, there's an exception, that any particular judge on their own or by application of accused with their counsel decides that the application of a mandatory minimum penalty would result in cruel and unusual punishment, has the ability to undercut that mandatory minimum penalty. But the exception is, with the exception of murder and treason, you have to impose a jail sentence. There is nothing in Bill C-16 that creates a threshold as to how low a sentencing judge could go. Hypothetically, you'd agree with me that a 1-day sentence for possession of child sexual abuse material in the most vile ways, as Mr. Seneville, as his collection was described, could result in a 1-day sentence followed by probation. Bill C-16 would not prevent a particular judge in this country, after this bill receives royal assent, from doing that, yes or no?
there would be no specific guardrails in the legislation.
Thank you.
Yep.
Thank you. Thank you, Chair.
Thank you, Mr. Brock. Mr. Gill.
Thank you. Thank you, Chair. And this amendment is about one thing, and that one thing is protecting our children. We need to safeguard mandatory minimum penalties to protect our kids and our next generations. Child pornography is not a minor offense. It is exploitation. It is abuse, and it destroys lives. Those who possesses it are fueling that abuse. Those who access it are creating demand for more victims. Canadians expect Parliament to stand with children, not with offenders. These amendments make it clear for offenses under Section 163.14 and 163.14.1, there will be no loopholes, no easy constitutional challenges under Section 7 or Section 12 while this law is in force. It also removes the Bill C-16 safety valve for these offenders. That is right decision. Conservatives believe serious crimes need serious consequences, especially crime against children. The Liberals often talk about protecting the vulnerable, and here is their chance to prove it. Will they stand with victims and families? Will they stand with the law enforcement trying to stop predators? Or will they protect offenders with more legal escape routes? This amendment sends a strong message. If you exploit children, there will be consequences. We need to safeguard mandatory minimum penalties to protect our kids. And I disagree with Mr. Housefather bringing that we brought notwithstanding clause every single time. It is for protecting our kids and sending a strong message to the predators that they cannot get away with these heinous crimes. If you consume these materials, there will be accountability. We must put our children first. Their safety matters more than the comfort of criminals. Conservatives will always fight for stopping the crimes of any kind. We will always defend victims, and we will always stand up for our children. I am supporting this amendment, and I urge all the members to support this amendment as well. Thank you.
Thank you, Mr. Gill. Mr. Bauer.
Thank you, Chair. I've been listening to the debate, and I've been listening intently to my friend, Mr. Housefather. I'd like to make a couple of comments in response, specifically with respect to the notwithstanding clause. I often urge this committee to consider the unique opportunity and therefore the obligation we have to consider legislation before us. I truly believe that many lives will turn on the work that this committee does. And that means not just the accused or law enforcement, but victims. And I wish that we would remember why we're here, and that's primarily protection of the public. The other thing I'd like to ask for, if there is one thing that I often find is absent from politics, and indeed sometimes it's absent from this building, it's nuance. And the notwithstanding clause is a very nuanced proposition. I agree with my friend from Montreal. You see, the first principle we have to agree on is that the Westminster parliamentary system is designed in a way that Parliament is supreme, unlike our neighbors to the south, where the Constitution is supreme. The Charter would not be adopted if it was not for Section 33. It was the deal breaker to make sure that provinces were comfortable, and of course the federal government would be able to avail itself of the same tool that
cannot be as grotesque as Mr. Housefather describes it if it is in itself, like Mr. Lawton said, is in the Constitution. The Charter cannot limit or prohibit something that it explicitly prescribes. The way to approach this legal question, just like with all statutory interpretation, is to look at the legislative intent, Mr. Housefather. We discussed the Attorney General Jean Chrétien. You spoke about Prime Minister Jean Chrétien. I was speaking about Attorney General Jean Chrétien. And I thank one of our capable colleagues who sent me the quote. In the words of Attorney General Jean Chrétien, if a judge were to strike down a law against child pornography on the basis of freedom of expression, the notwithstanding clause would be there to allow Parliament to fix such absurdity. I very much take exception to the fact that Mr. Housefather is suggesting that this amendment is not responsible. This amendment is precisely in keeping with the spirit of Section 33. Mr. Housefather is correct in that in the last couple of years, we have seen the exercise of Section 33 again and again. And he's also correct to refer to Prime Minister Brian Mulroney, who said that the Charter may not be the paper it's written on because of Section 33. But I disagree with that very much, because there was an overriding principle to the framers of the Charter. And I've actually been asked that question multiple times by students. And the question would always be, but Mr. Baber, what would prevent a government from exercising the notwithstanding clause, from invoking the notwithstanding clause every time it desired to do so? And the answer that I believe is twofold. It's political accountability and decency. Political accountability and decency is the mechanism by which the notwithstanding clause would not be used. Political accountability is specifically factored into the notwithstanding clause, in that there's a sunset clause, as Ms. Latanzio correctly pointed out. And if I'm incorrect to suggest that we should safeguard the mandatory minimum penalties for folks that hold in their possession 250 videos of children being raped, then I may pay that political price. And at the same time, it's decency. It's that slippery slope that maybe my liberal friends refer to, that would prevent a responsible government from invoking the notwithstanding clause. And so we have the legislative intent framework, but we also have the reference to the rationale behind the existence of the clause. When Mr. Housefather says that he's been hearing the Conservatives talk about the notwithstanding clause a lot, well, in this committee it's only been spoken with respect to Seneville. And I correctly, I point to Mr. Brock, who said, it's interesting that the safety valve does not apply to treason or to murder, because it looks to me as if the Liberals have decided that on the scale of moral turpitude, of offenses that should really have the court throw the book at the accused, murder and treason should not be offenses from which judges should be able to deviate. But child pornography, access and possession of child pornography can be. It's actually very instructive, Mr. Brock, because maybe what we're hearing from the Liberals on the safety valve, that it's supposed to safeguard mandatory minimum penalties, while not introducing the safety valve for treason and murder, teaches us something, that maybe it's not there to safeguard mandatory minimum penalties, but specifically to be excluded from the application of the safety valve that can potentially undermine it. Think about the use of the notwithstanding clause in the last couple of years. I was looking forward to seeing my friend Ms. Begum today, who I thought was added to the committee. Her and I served at Queen's Park for a number of years. And I was looking forward to actually reminding her about a number of debates we had at about the notwithstanding clause in the Ontario government, and how you can differentiate what is appropriate and what is not appropriate. After the election of the Ford government, in Bill 5, the Ontario government sought to reduce the size of Toronto City Council because it campaigned on the fact that government is too big and too inefficient. And because there was a good probability that the courts may strike down the Ford government's attempt to rewrite municipal structure and law in the midst of a municipal campaign, that the Ford government elected to preserve the legislation with the notwithstanding clause. Well, I would say, look, if it's a stated priority, if I campaign on the fact that this is my priority, legislative priority, and I get that mandate from the electorate, then it is within my purview to safeguard that priority. And if it was not within my mandate, then the voters will tell me before the sunset clause expires. The Ford government won on appeal, in that it was concluded that the invocation of the notwithstanding clause in that situation was, that the legislation was itself constitutional and invocation of the clause was not required. But what happened a couple of years later, that Ontario did invoke the notwithstanding clause. And to anyone who doesn't remember the circumstance of that, it was on elections legislation. It was the Safe Elections Act or something like that, because everything had to be safe at the time. And the suggestion was that, we have to, I'm on record, I debated this. The suggestion was that we had to prohibit large third-party foreigners from interfering in our election. What realistically that legislation did is it precluded anyone who wanted to spend $500 on posters that my MPP doesn't respond to my phone calls from putting a poster, spending more than $500, which would require $400 in compliance. And on that legislation, the Ford government decided to invoke the notwithstanding clause that was self-serving elections legislation. And that would be politically indecent. So I beg exception to Mr. Father's remarks to suggest that the amendment that I proposed to protect Canadian children, and children, in fact, all around the world, is irresponsible. I would say, with respect, it would be irresponsible not to adopt my amendment knowing that it could protect children, and to rely on a safety valve that would allow a judge to disregard a mandatory minimum penalty, to lean on a safety valve that we decide should not be applicable for murders and treason. Probably for good reason the Liberals decided that. Leads to the precise opposite interpretation. Let's not miss this opportunity. Let's protect children. Let's celebrate Canadian heritage. Let's celebrate the Charter. This is what I'm trying to do here, Mr. Housefather.
Is that it, Mr. Bauer?
Actually, I want to add one last point. Yeah. I appreciate the chair allowing me to take a breath and think. I was very proud during the last election campaign when the leader of my party, Pierre Poilievre, said that he would use the notwithstanding clause in connection with the bail and sentencing legislation in some very discrete cases. If you have an absurd situation
where a violent repeat offender is out again and again, a scenario that we have contemplated in this committee repeatedly, that would be the precisely type of absurdity that responsible government should address and prevent. So it's entirely consistent, intellectually, historically, and legally, to say that, no, it's not willy-nilly. It's when it's government priority, when it's essential, when there's absurdity, and it's politically responsible, and there will be accountability. And in all of that, decency will be maintained. It's very, very regretful that we can't agree on the use of the notwithstanding clause, because we can no longer agree on decency in politics. That's a new thing. That is a new thing, which maybe is even worse than all of this. Thank you.
Thank you, Mr. Baber. Shall Clause 13 carry? No. CPC 13 carry, sorry. Okay, let's do a recorded vote. Do a recorded vote.
On CPC 13, Mr. Chair?
Yes.
Madame Latanzio?
No.
Monsieur Housefather?
No.
Madame Dillon?
No.
Mr. Chang?
No.
Madame Khalid?
No.
Madame Gladzu?
No.
Mr. Brock?
Absolutely.
Mr. Baber?
Yes.
Mr. Gill?
Big yes.
Mr. Lawton?
Yes. Yes.
Mr. Fortin?
No.
Defeated.
Defeated. Okay, shall Clause 17 carry? Carried. Shall Clause 18 carry? Carried. 17 was on division, okay. 18 carries? Okay. Which takes us to Clause 19, which is CPC 14. Who's going to speak to that? Mr. Lawton.
Thank you, Mr. Chair. I am moving CPC 14, which amends in Clause 19 the bill by adding after line 39 the following, 5.1. If the illicit material is an intimate image as defined in subsection 162.12, in relation to which an offense was committed under section 162.1, the court must order the custodian of the computer system to delete the material within 48 hours after the order is made. Just if I can very briefly add some context, this is also an amendment that came about from witness testimony. And while C16 is focused on criminal penalties, among other things, we have to acknowledge that we are trying to serve victims in what we're doing. And one of the testimonies in particular I'd like to highlight was from Madame Suzanne Zacour, who had said, and I was asking her about whether civil remedies might be more suitable than criminal remedies for some of what she wanted to do in removing intimate images from the internet. And what Ms. Zacour said is that what victims most want is a remedy to remove the photo from the internet, unquote. And I think that's something that we're trying to achieve here. It's certainly what I was thinking of when putting the amendment together. It isn't just about sending a strong signal and penalty, which is important, but it's also about ensuring that, to Ms. Gazan's point, that tech companies are aware they have a responsibility here and trying to minimize as much as possible the harm that these images will and often do cause for victims by being available online. So that's what we're hoping to do here, and I hope we'll have full support from the committee for this.
Thank you, Mr. Lawton. Anybody else? Ms. Gladue.
Thank you, Chair, and it's a pleasure to be here talking about C16. When I was Chair of Status of Women for many years, a lot of the recommendations that are in this legislation came forward, and certainly we did hear testimony similar to what Mr. Lawton is saying about the need to be able to have a mechanism to remove the pictures and the images that are there, so I do support this.
Thank you. Mr. Fortin.
Merci, Monsieur le Président.
Thank you, Chair. I believe it's an important issue. I intend to support it, but I wonder about the 48-hour deadline. I think it's important and it's urgent, but is it realistic? There's no margin of maneuver. We are saying that the court has to order erasure, and if an order is issued, it should be done. I wonder about the possibility of doing it in 48 hours, and I would like to know what the analyst or the jurists have to say, but I agree with the principle.
Who wants to field that one?
And bring a colleague up to the table, Mr. Wong.
Yeah, absolutely, that's
right,
fine.
thank
Yep.
Merci pour la question, Monsieur.
Thank you for the question, Mr. Fortin. I will respond in English, if it's possible.
8 hours, I'm not entirely sure. This amendment, we haven't had a chance to study it. The way that 164.1 works currently is that the judge orders the takedown, and that is interpreted that it's the immediate takedown. So the timing of the 48 hours, it's unclear to us whether or not that would actually delay the removal of the intimate images or if it would actually speed things up. Whether or not it's possible, we have not had an opportunity to talk to service providers who might be hosting this type of material.
Donc, ça peut être possible.
So it may be possible, but you are not certain.
Exactement, ça peut être possible. Mais
Exactly. It may be possible, but we are not very certain.
Et j'aurais... Ça va, Monsieur le Président?
I have another question, Mr. Chair, on the same topic. Has there been any verifications with the provinces to find out whether in the administration of justice this is possible?
sur la question de sens,
On 164.1, no cases have been reported because since 2001, and the update on the criminal code, there has been no cases because internet service providers, when they are notified about anything on their networks, they immediately remove it without needing an order from the court. Thank you.
Thank you, Mr. Fortin. Mr. Lott? No, you're good? Okay. Okay. Ms. Gladue?
Yes, just some information for you, Mr. Fortin. When we did study violence against women and girls, there was a specific case, Rhea Parsons, where she ended up committing suicide because images couldn't be taken down. And there was a web provider called needhelpnow.com that was able to get 95% of content down within this time frame. And so we challenged Meta to go and do the same. And so they introduced a mechanism where you can report content and have it removed if it's objectionable. So I believe it is possible, and those are just two examples.
Thank you. Okay. Shall CPC 14 carry? Yes. All right, carried. Shall Clause 19 carry? Yes. As amended? Okay. Shall Clause 20 carry? Yes. Shall Clause 21 carry? Yes. Shall Clause 22 carry? Yes. Shall Clause 23 carry? Yes. Okay, PB 3 has been withdrawn. Shall Clause 24 carry? Yes. So Clause 25, which takes us to CPC 15. Who's up on that one? Mr. Lawton?
Request a very brief suspension of about 90 seconds, Chair.
I will do it on the condition that nobody leaves the room.
Okay.
Okay. Lawton, you had the floor.
Thank you very much, Mr. Chair. I would like to move CPC 15, but I just wanted to provide a bit of context on this one first. And let me just say, and I genuinely trust, despite our disagreements across party lines on some parts of this legislation, that we all understand the horrors of intimate partner violence. And I think we cannot look at that while understanding that intimate partner violence can happen to both men and women. We know that women disproportionately bear the brunt of this. And this has been an issue that I have been very fortunate to never have encountered in my family, but I have had friends that have, women that have been in very abusive relationships, one that had to leave the country to feel safe. And I have also been very grateful to have testimony from witnesses that I sought to include in this committee's work locally. The London Abused Women's Centre in London, Jennifer Dunn was very, very eloquent in her comments, as she always is. From Valora Place in St. Thomas as well, we had Chief Tai Trong from the London Police Service, which has also been a tremendous advocate for protecting women from the violence that sadly all too often faces them and confronts them. And one thing that came up in the testimony we heard before this committee and other conversations I had, including with Megan Walker, who I've come to know quite well, formerly the executive director of the London Abused Women's Centre, is that we need to have explicit protections and explicit reference to women when we're talking about femicide. And this was something that came up in multiple witnesses' testimony, where femicide was alluded to in a header, but not actually defined or established with any degree of clarity in the bill itself. So my amendment, simply put, replaces intimate partner violence with femicide. And this is something that, again, women's advocates have argued is important because they believe IPV is too euphemistic and doesn't actually speak to women and speak to the issue. And it defines it very clearly. Femicide is first-degree murder when the victim is female and the death is caused by her intimate partner. It's a very clear definition. It's a very simple one, and it's one that acknowledges the horrific harms that women in abusive relationships have to confront in these cases, tragically, when there is a murder involved. So I welcome any feedback and input from the committee on this, but that was where this came from and the consultations that went into this amendment.
Thank you, Mr. Lawton. Ms. Latanzio?
Thank you, Mr. Chair, and I have a question for the officials. So on this proposed amendment, would you not agree that it narrows femicide to killings of female intimate partners, removing other contexts like coercive control, sexual violence, exploitation, and misogyny? And in your opinion, does it undermine the broader intent of C-16 and removes protections for other high-risk contexts and victims?
Thank you for that question. It does remove 3 of the circumstances, exploitation, sexual violence, and misogyny. Those are in paragraphs 231, 5.1b, c, and d, and then it fundamentally changes A to apply only where the victim is a woman and is the accused intimate partner. It removes the concept of coercive control entirely and wouldn't protect victims of other genders who may be also subjected to coercive control. I think maybe the bigger concern in terms of what the overall objective of this provision is that it removes key provisions. So the sexual violence provision is the one that would apply anytime a murder occurs where there is an offense of a sexual nature or an offense that's committed for a sexual purpose also occurring at the same time. And the concern about that is targeting cases that we know have occurred. For example, the Picton case, which involved somebody who murdered many women in the course of purchasing sexual services from them. So that provision would capture that type of a scenario. All kinds of murders that would take place in the context of sexual violence is quite broad. The characterization of offense of a sexual nature is any offense that involves an act that is objectively sexual in nature, and then an offense that is committed for a sexual purpose is one that is committed with intent to facilitate an act of a sexual nature. So removing that, I think, defeats the purpose of identifying that aspect of femicide. And of course, removing the hate-motivated aspect means that this provision would no longer cover cases like the tragedy at Polytechnique, the incel cases that we've had, et cetera, and then the exploitation one would mean that it wouldn't cover situations where labor or services are exploited and a murder occurs in that context. I'd also say that this provision does provide an effective definition of femicide. What it does is say that anytime a female is killed in any one of these circumstances, that is femicide. So there is a definition built into this provision. I hope that helps. Thank you very much.
Thank you.
Thank you, Ms. Latanzio. Seeing no others, okay. Oh, I'm sorry, Andrew. Yep, sorry, Mr. Lawton.
Sorry, so I just want to understand that last comment a bit more clearly, if I could, please, Ms. Levin. You're saying that femicide is implicitly defined in the legislation, but not explicitly defined?
Well, I call it more of an effective definition because the marginal note, which identifies the content of a provision for awareness reasons and for being able to identify what's in a provision, you're right that it doesn't have force of law, but it certainly labels the provision. And it's the marginal note is femicide and other aggravated circumstances. So what that means is that when a female is killed in any one of A, B, C, or D, those circumstances, as I've described them, the legislation is defining those circumstances as femicide. That is my understanding of the effect of that provision.
But 5.1 is gender neutral, you also said.
Yes, because the goal is to protect all victims who may be killed in those situations, but labeling it femicide recognizes that women are disproportionately impacted in these circumstances, meaning that they are disproportionately the victims of these types of killings. And that's why the marginal note says femicide. But the intention, as I understand it, is to protect everyone who might be murdered in these 4 situations.
I'm not debating. I realize you're not the sponsor of the legislation, so I'm making an aside, if I could, from my interaction with you. The concern that women's advocates have raised is that by making it gender neutral, it is diminishing the fact that women do bear the brunt of this. So returning to my questions, and I don't know if this is better suited for you, Mr. Taylor, or you, Ms. Levin, or one of your colleagues, was there any rationale given for why not to explicitly define femicide in the legislation?
Chair, if I could ask a clarification on that question by explicitly define.
If I may, why not include femicide in the substantive and operative text of the legislation itself? Why is it only in the marginal note? Why is it not clearly spelled out? Because that lack of definition has been the concern that has been raised in witness testimony and also other stakeholder dialogue.
There are other groups that are also disproportionately impacted by these 4 circumstances, including gender diverse people who may not identify as female. So as I understand it, a decision was taken to ensure the protection of the law for everyone who could be subjected to murder in these circumstances. And we know that although it's predominantly females, there are other groups who are impacted, and they deserve the protection of the law too.
So how would 5.1D not already be covered by other legislation, including, I mean, as recently as Bill C-9, which deals with hate-motivated offenses? You know, why does that need to be spelled out specifically in this when we already have provisions dealing with motivation, a hate motivation, regardless of whether it's about sex or religion or anything else?
Thanks for that question. I mean, you are right that C9 is very much focused on hate-motivated crime. This committee knows that quite well. You will recall that the government, when they campaigned, Liberal Party campaign, one of their commitments was to treat hate-motivated murders as first-degree murder. Certainly in the work that Parliament has done around coercive control at the FEWO committee, the work of stakeholders, civil society organizations had brought to light concerns around femicide, as you've spoken to, Mr. Lawton. Fundamentally, it was a choice in terms of how to address both of those important objectives, and the choice is what is reflected in C16.
The concern that I have with this is that we have one section which is presented as being about one thing, but in the actual text is about a number of things. And again, just to follow this to its logical conclusion, if someone murders someone because of the victim has a physical disability. It is a man with a physical disability that is murdered by someone who had, pure hate in their heart. We would all condemn that. We would all want a very stiff penalty. But that is being captured under the same definition that's being presented to women as being an answer to femicide. And I guess I'm having trouble understanding how this section on femicide and intimate partner violence has such a broad catchment area. And I'm just wondering why this is all being done in one particular section. If you can speak to that, and if it's a decision that the government needs to answer, that's fine. I just didn't know if that's something you had any light you could shine on. I try to avoid the compound question if I can. So why is, killing someone because of their mental disability being viewed in the same clause, the same subsection as femicide of an intimate partner, which has a very specific and very unique dynamic which C16 purports to address?
Thank you. Yes, well, these are all of the enumerated grounds that are in all of the hate-motivated provisions in the code. And I would direct your attention to the marginal note, which clearly says, and other aggravated circumstances. I think that Canadians would agree that those types of murders that have just been described, Chair, are also heinous and deserving of a strong legal response. And so I understand that the objective of this provision is to properly label all aggravated circumstances in which people are killed, and to say very clearly that when it is a female who is killed in these circumstances, that amounts to femicide, and that will help, or the intention, as I understand it, is to assist law enforcement and others in gathering the data that we need to properly assess and evaluate this societal problem that we are dealing with, and also a basis on which law enforcement may develop policies so that they can properly name killings when they occur for the public.
If my Liberal colleagues or anyone else on the committee wish to offer any sub-amendments, I would welcome that discussion. Certainly there's no desire to narrow what the bill is trying to do here, but I hope we do not lose sight of the overall objective here, which was that if we are going to have legislation that is there to speak to women and to address these concerns head-on about intimate partner violence and specifically the effect it has on women, I believe that femicide needs to be clearly spelled out, and it needs to be clearly acknowledged as having its own dynamic, which is distinct from these other things, which again are not points of contention, but it's trying to lump it all under this one banner. Thank you, Mr. Chair.
Thank you, Mr. Lawton. Ms. Gazan wanted to speak first, and then I'll go to Mr. Housefather.
So I don't know whether this is helpful, but I have a question because, I mean, I understand certainly the intent of Mr. Lawton in terms of clarity, but I mean, we know from the final report, the highest rates of femicide and murder are against Indigenous women and diverse gendered folks. I would say the acronym, but Elon Musk, apparently I insulted his intelligence. He can't remember the acronym that was actually used in the final report. But in saying that, is that the intention of the bill? Because I think when we're talking about intimate partner violence, yes, there is femicide, but if we're looking statistically at actually dealing with the issue, we have ample research. There's lots of things I disagree within this bill, but I think, is it your intention that, or is it your understanding that failing to do so would also fail to rectify groups most impacted by intimate partner violence? And quite frankly, what's missing in this bill is the massive amounts of gender-based violence that happens against certain populations outside of relationships.
So I would just stress for the committee that it's only A that deals with the intimate partner violence issue directly. Now, that's not to say that there couldn't be situations that are overlapping between the 4 different circumstances. For example, there have been cases like this where a person has killed their wife in the context of sexual violence. That would be treated under A and B. But to answer the question more directly, I do understand the overall objective of this amendment to be to protect everyone, to recognize that, yes, women are disproportionately represented in A, B, C, and D circumstances, as in the bill, but there are other groups who might not identify as female, might not consider themselves to fall within that rubric, and might not want to use the term femicide for their murder, but there is no substantive difference between, or no difference between the moral culpability of that one person killing a gender diverse person, let's say, in the same circumstances as B, let's take it as an example, or killing a female person in that circumstance. So my understanding of the overall objective of this provision is to very clearly denounce these types of killings, while also clearly recognizing that when a female is the victim of any of these types of killings, we need to call that what it is, as the stakeholders have clearly stated, stakeholders like Megan Walker and Jennifer Dunn from the London Abused Women's Centre, that it's very important to label that as femicide. We've heard that again and again, and we've heard that we need to collect information, data on this, so that we can keep track and we can really try to prevent this from happening. And of course, that's what the coercive control offense is aimed at, but we're not there yet. So I will stop there. Thank you.
Mr. Housefather.
I was just going to say that I think the provision is okay as is, because as was indicated, and other aggravating circumstances is there. And someone, if you have an equal situation, well, someone is attempting to commit an offense of a sexual nature, an offense for a sexual purpose, for example, under C, it doesn't matter who the victim is. It's exactly the same offense. So I think that there's a misunderstanding, because the first word, femicide, deals with one subgroup of this clause, but there's other people that are equally vulnerable that are also covered by this clause, and people who might not be viewed as vulnerable, cisgender white men, could potentially be covered if they're a victim of the same circumstance under this clause. The issue is there is a clause that generally sets out for subgroups that then will attract a first-degree murder charge. I think it seems fine to me. Anyways, but I appreciate, Andrew, your thoughts.
Okay, shall CPC 15 carry?
Yes.
Okay, we're going to have a recorded vote.
On the,
You may have been louder, I'll give you that. I'm not just sure you were. Yeah, I'm not sure you outnumbered them, which is what really counts, so.
thank you, Mr. Chair. On CPC 15, Madame Latenzio?
No.
Mr. Housefather?
No.
Madame Dillon?
No.
Mr. Chang?
No.
Madame Khalid?
No.
Madame Gladu?
No.
Mr. Brock?
Yes.
Mr. Barber?
Yes.
Mr. Gill?
Yes.
Mr. Lawton?
Yes.
Monsieur Fortin? Defeated.
Okay, defeated. Okay, so shall clause 25 carry? Yes. Shall, on division? Okay. Shall clause 26 carry? Yes. Okay, so now we're into new clause 26.1, which I've also reviewed, and for reasons that are consistent with my previous rulings, I'm ruling this one out of scope.
Challenge, please.
Okay, Mr. Clerk?
Sorry. I'd like to speak. I'd like to speak to this issue now.
What would you like to speak to?
To your ruling.
There's no speaking to it, I've already ruled.
Okay. Well, we've heard something different from the officials, right? We've heard from the officials that this is what this legislation does.
Mr. Babber, I am not going to argue with
Yeah.
you. We've been through this before. I'll say what I said earlier. I gave Mr. Brock an opportunity to speak at the outset because all of these amendments, all of these proposed amendments were being deemed out of scope for very similar reasons. I thought that was fair. There is no provision when I rule for you to make submissions. I realize you are making Twitter clips during the course of this thing. I would include in those Twitter clips that we have rules at this committee and they are to be followed, and I'm trying to enforce them. It's as simple as that. Mr. Clerk, over to you.
Except that the officials told you.
Mr. Babber,
Well-
discussion's over.
On the,
Officials told you that what the bill
Babber,
does
Mr.
is it
Babber, we're
restores
going to a
mandatory
vote.
minimum. One
Mr.
second.
No, what? No, not 1 second. We have rules, Mr. Babber. We're following those rules.
I'd like one.
Mr. Clerk.
on the motion, shall the chair's ruling be sustained? Madame Latenzio?
Sustained, yes.
Monsieur Housefather?
Yes.
Madame Dillon?
Yes.
Mr. Chang?
Yes.
Madame Khalid?
Yes.
Madame Gladu?
Oui.
Mr. Brock?
No.
Mr. Babber?
The officials said that the
It's a
legislation
yes or no
restores
question, Mr.
mandatory minimum
Babber.
sentences. This is
It's
an
a yes
extension
or
of
no
it.
question, Mr.
No.
Babber.
No.
Okay, move on to the next
Mr.
person.
Gill?
Thank you.
No.
Mr. Lawton?
No.
Monsieur Fortin?
Oui.
Sustained.
Okay. Which takes us to CPC 17, which I've, for same reasons as previously stated, I am also ruling out of scope. Mr. Clerk?
On the motion, shall the chair's ruling be sustained? Madame Latenzio?
Yes.
Mr. Housefather?
Oui.
Madame Dillon?
Yes.
Mr. Chang?
Oui.
Madame Khalid?
Yes.
Madame Gladu?
Yes.
Mr. Brock?
No.
Mr. Babber?
No.
Mr. Gill?
No.
Mr. Lawton?
No.
Mr. Fortin?
Oui.
Sustained.
Thank you. Okay, which takes us to clause 27, which is NDP 5, which I'll turn the floor over to you, Ms. Kazan.
Thank you so much, Chair. So,
Sorry, I should point out, if NDP 5 is adopted, G4 cannot be moved due to a line conflict. Sorry, go ahead, Ms. Kazan.
thank you so much, Chair. So, this one is from Null as well. Experts have told us the change to the category of harassment in Bill 16 is problematic. In the recent past, charges of harassment were dismissed because women being harassed did not show signs of fear despite the intent of harassment. And I just want to point out that not showing signs is a subjective observation. What we found in the Status of Women Committee is that often police and people that are kind of first responders to the event are not trained, particularly in instances of coercive control, nor are judges, in fact, because it's a very new area, and I know it's an area of the bill that attempts to address or add to the criminal code. Additionally, somebody who's aware that a victim holds an unreasonable fear, such as an example of a phobia of spiders, could use this knowledge to willfully harass victims. Some of the things that maybe somebody wouldn't see, but that the person that's perpetrating the violence is using to intentionally traumatize their victim. There's also a lot of concerns surrounding threats made to animals like pets, and it expands this category to include other pets known to the victim, such as an animal of their friend or partner. This remains an act of violence. And this is actually a really big deal. A lot of people experiencing intimate partner violence will not leave because they are scared with what will happen to their pets, to the point where there's been studies, and certainly in Winnipeg, in transitional housing, where they now allow pets so that people that are fleeing violence don't have to worry about their pets. Things like threats to kill their pet. It sounds peculiar, but it's actually really common for perpetrators of violence to use violence and threats against pets as a form of coercive control to trap victims. So we're hoping for that amendment. We're hoping that you support that amendment. Thank you.
Okay, Ms. Latanzio.
Thank you, Mr. Chair. Thank you to the member for bringing forward that amendment. Although we agree with the intent behind this amendment, we are going to oppose it, or I will oppose it, because the amendment that we brought forward more specifically in other amendments that we will see further down address the same issue but use more precise consent language in our structure to avoid unintended impacts in sensitive situations, including where capacity or emergency considerations are at play. So because of that, I will be opposing your amendment, but not because of the intent. Thanks.
Okay. Shall NDP 5 carry? No. Okay, defeated. Okay, so that takes us to G4. Who's up? Ms. Dillon?
So to, let's see, this motion would amend subclauses 27(1) of the bill to clarify that the criminal harassment offense applies to a person who knows that their conduct would harass the victim, and not just to a person who intends to harass the victim or who is reckless as to whether their conduct would have that effect. Stakeholders have pointed out that the offense does not specify that an accused who knows their conduct would harass the victim is also committing the offense. So this amendment would clarify that fact.
No one else? Okay. Shall G4 carry?
Yes.
Carried. Okay. Takes us to NDP 6. Okay, since NDP 6 is deemed moved, G5 cannot be moved as they are identical. So, Ms. Gazan.
It's similar to the other amendments to ensure that threats against a pet animal or anyone known to the victim, such as a parent, child, or friend, is included in this offense.
Thank you. No one else? Okay, shall NDP 6 carry? Yes. Carry. Okay, so G5 is redundant? You want me to say it? You want me to say it again? Okay, which takes us to, okay, shall clause 27 carry as amended? Yes. Okay. So we'll go to clause 28, PV4 is... We're good? Okay. So clause 28, PV4 has been withdrawn, which takes us to CPC 18.
Thank you, Chair. CPC 16.
18.
Oh, sorry, 18. Thank you. CPC 18 seeks to conform the new offense of coercive control to the rest of the criminal code effectively, with a few exceptions. There are various levels of the guilty mind of intent. Willfulness is enough to prove intent. Knowledge, so knowingly,
willful blindness is the flip coin of knowingly, but recklessness normally is not sufficient to predicate the making out of the mens rea component, with few exceptions like manslaughter, wanton disregard, failing to provide necessities of life, etc. That's what this amendment seeks to do, is to remove recklessness. Thank you.
Thank you, Mr. Babber. Anybody else on CPC 18? No? Shall CPC 18 carry? Okay, I got to go into volume versus numbers again there, so we'll have to do a vote.
Thank you, Mr. Chair. On CPC 18, Madame Latanzio?
No.
Mr. Housefather?
No.
Madame Dillon? Mr. Chang?
Nope.
Madame Khalid?
Nope.
Madame Gladu?
No.
Mr. Brock?
Yes.
Mr. Babber?
Yes.
Mr. Gill?
Yes.
Mr. Lawton?
Yes.
Mr. Fortin?
No.
Defeated.
Defeated. Okay, so now we go to G6, or sorry, yeah, G6, yeah.
Chair, because we adopted NDP
You're
6,
quite
does
right.
that mean that mine drops?
You're quite,
G6, yeah.
you're quite right. So just before I say yes to that, I want to hold on. No. No, it was NDP 6, and yeah, we're getting.
It was G5.
G6 is okay to go ahead.
G6 is.
Yeah, yeah.
Okay.
So, Mr. Chair, I'll move G6. G6, though, it puts in a different place in the bill the same issue that we've dealt with before, that an animal known to the intimate partner could be the subject of a coercive of control, rather than just someone that they own or they have control over. For example, if I threaten to harm your mother's dog, it could be as damaging to me as if you threaten to to harm my dog. So it's the same that we just adopted, just in a different place.
Thank you. No one else? Okay, shall G6 carry? Yes, okay. G7, if G7 is adopted, NDP 6.1 cannot be moved due to a line conflict. So who's up for G7? Mr. Housefather.
So, Mr. Chair, this adds a new element to the coercive control offense. It would treat damaging or threatening or attempting to damage the victim's property or the property of anyone known to them as conduct that could threaten safety. And there's a list of conduct that is included, and we would just be adding it to that.
Mr. Brock?
It's really, firstly, I support Mr. Housefather. I want to make that abundantly clear. It's very odd that you often have any member of the Liberal Party championing property rights, so this is an exception to that general rule. But I also want to make a general comment, Mr. Chair, that it's something that I looked at when I got this bundle of amendments on Friday, and I totaled the number of amendments brought by each party. I was actually shocked that the number of Liberal amendments literally doubled the amount of opposition amendments, which really speaks to how rushed, in my view, C-16 really was. If the government has to amend a bill that they have been championing for literally for the last year. So this is an example of failures by this justice minister who took his marching orders from Prime Minister Carney to deliver substantive reforms on justice issues, but clearly, after hearing from a number of witnesses that should have been consulted, in my view,
Point of
long
order,
before.
Mr. Chair.
What's the point?
It's on relevance to the
It's
amendment.
relevant. I'm getting to that. I'm not quite finished yet, but good attempt, Ms. Khalid. Attempts to rectify what should have been done up front is exactly what this Liberal government is trying to do now. So I want to put that out there because it's rather ironic that you ever get to a situation on clause-by-clause consideration across the number of standing committees that we have here for the federal government, that we have a situation such as this. But nevertheless, we are supportive of this particular amendment because we do also champion property rights.
Put that down as support, but unenthusiastic support.
No, it's enthusiastic.
Okay. Mr. Housefather.
Yes, thank you, Mr. I just wanted to say a couple of things in response to that. I restrained myself before, but I will just briefly respond. First of all, the Prime Minister himself talked about property rights and how important they were in the House today. But secondly, I think it actually shows, number one, that Liberal members of the committee listen to witnesses, and that within our party, you're allowed to make modifications to a bill. Yeah, I think it actually shows the opposite of what Mr. Brock is suggesting. And I would also note, Mr. Chair, for the purposes of the number of amendments, a significant number of these amendments are consequential one to the other. Just because you have multiple amendments doesn't mean you have a million different concepts. Some of the changes, if you make a change to one clause, in some cases you have to make it to 5 or 6 other clauses in the Liberal amendments. Some of them are consequential one to the other. So I don't think either of his points were correct, but I do appreciate very much that he's supporting the amendment that I put forward.
I support you.
That was weird. Okay. Okay, thank you.
Point of order.
Sorry, Ms. Gazan.
So I have no vote, but I do have a thought. So I understand that you're talking about the amendment and it would delete my 6.1. Is that, no? Is this, like, if we accept your amendment, are we still able to move forward with my amendment of 6.1?
No.
Oh, okay.
No, we can't.
So because my amendment actually doesn't deal with what we were talking about, it comes from the Union of BC Indian Chiefs, specifically around self-harm and mental crisis that disproportionately potentially criminalizing those that are experiencing mental health crisis due to the legacy of residential school and genocide, and this fits into Gladue and Ippley principles, especially if you're looking at the highest rates of violence with Indigenous women. These factors do impact our families, residential schools, and PTSD. We also know that Indigenous people are disproportionately impacted by the carceral system, and we're passing legislation that reinforces and perpetuates this legacy of systemic racism. And in all the bills, and I know the Conservatives have brought up Bill C-5, it pushes back against Gladue and Ippley principles that could be used by courts in cases of residential school survivors. For example, not having to justify trauma based on their historical experiences. So I know that I don't have a vote, but I think it's unfortunate, especially if you're looking at populations most impacted, that we just ignore that.
Thank you, Ms. Gazan. Okay,
Point of order.
Go ahead, Mr. Lawton.
So I was hoping to, I have questions that I was hoping to ask the officials about 2C. Now, the questions are not pertaining to Mr. Housefather's amendment specifically. I just, for clarity on process, can questions be asked of officials when we get to the overall decision on the clause itself? Okay.
I believe so, yeah.
Okay, that's fine. Thank you.
Yeah. Okay. All right. So, shall G7 carry? Yes. Okay. So NDP 6.1 then is up there. So then we get to CPC 19. Mr. Lawton?
No.
Yep.
They got rid of it.
G7.
There was a line conflict between G7 and NDP 6.1, Mr. Fortin, and because G7 was adopted, we can't move 6.1.
Tout respect, Monsieur le Président.
With all due respect, Mr. Chair, that's not what I'm reading. In my opinion, 6.1 should have come before G7. G7 talked about an addition after line 28, so after paragraph 7I that Madam Gazan talked about. So I do not believe that one excludes the other, with all due respect. I'll leave it up to you to decide.
All right, so we're on to, back to CPC 19. Thank you.
Thank you, Mr. Chair. Building off of the comments made by one of my colleagues here before, the coercive control is a new area in law, and I think it is important to get it right. I think it's important to encounter and confront a lot of the feedback we've gotten from both sides of it. I actually looked to a former New Democrat MP on this one, Laurel Collins, in the previous Parliament, who had put forward a coercive control bill that I believe had support from all parties. This was just a defense that was from that on coercive control, just to provide absolute clarity on the types of conduct and conflict and disputes within relationships that do not qualify as coercive control. So that's the spirit of this of CPC 19. It is just adding. Sorry if I. Thank you. So 3.1, if an accused is charged with an offence under subsection 1, it is a defence that A, the accused was acting in the best interest of the person towards whom the conduct was directed, and B, the conduct was reasonable in all the circumstances. So it's just taking the language from Laurel Collins' bill in the previous Parliament, C332.
Thank you, Mr. Lawton. Anybody else? No? Okay. Shall CPC 19 carry? Yes. Okay, we'll have the recorded one.
Thank you, Mr. Chair. On CPC.
Supported in the last Parliament.
Are we voting?
You all did.
Okay.
It's a reasonable.
Okay.
It's a very reasonable.
All right, we're having a vote.
It's
On
identical.
CPC 19, Madame Lattanzio? No. Monsieur Housefather?
No.
Madame Dillon?
No.
Mr. Chang?
No.
Madame Khalid?
No.
Madame Gladue?
No.
Mr. Brock?
How their memories are so fleeting. Absolutely, I support this.
Mr. Weber?
Yes.
Mr. Gill?
Yes.
Mr. Lawton?
Yes.
Mr. Fortin?
No.
4-7.
Okay, so
J'ai un petit point d'ordre, si vous permettez.
Point of order, Chair.
go ahead, Mr. Fortin.
Oui, c'est un.
It's a point of order. I don't want to make this an endless problem. A while ago, looking at the amendments, NDP 6.1 and G7, I understand your intervention, but the analyst showed me that indeed, in the English version, you are right. Line 36 is eliminated, but in the French version, it could have worked. I'm being told that the English version is more valid than the French version. So in that case, Mr. Chair, I would like to say that this runs contrary to parliamentary regulations, where the two versions should have the same validity. One should not be more important than the other. I know that we have a dilemma. If I were a lawyer, I may have done the same thing. I'm not blaming you. But I want to say that in drafting our amendments, we have to make sure that the two versions have the same precedence, which is not the case here. I would have voted against the NDP amendment, but the principle is that we cannot say that the English version prevails over the English. That is a problem to me.
I'm going to let the analyst answer the question.
Merci, Monsieur Fortin.
Thank you, Mr. Fortin. To clarify, procedurally, it's not about something taking precedence over the other. It has to do with procedure because the French version tends to be longer. So to avoid any confusion, when we look at the documents, we look at the English version first because the English comes before the English version. So to avoid any confusion, we want to have a consistent approach. So we look at the English version when there's any line conflict. The judicial effect is the same. It's just because the two versions are drafted differently and the practice is to follow the lines in the English version. It's not very often that we see such situations where we see a clear distinction between the lines in English and in French. But the practice we use is to look at the English version first. Thank you, Madam Analyst. However, I would like to say that if we were to take the French version, it will work. G7 said add after line 38, and NDP 6.1 said amend by removing line 37 and 38. We could have adopted the two without any problem, in my opinion. Once again, I don't want us to spend an hour on this, but I think this interpretation method is a problem, and at some point, it may have a significant impact on the substance. Thank you, Mr. Chair.
I want to make sure you're comfortable with this. We can suspend for a moment if you want, just make sure we're on the same page.
Même si on suspendait,
Even if you were to suspend, there's nothing more I have to say, Mr. Chair. I've explained the problem. It's not about personal comfort. It would not change anything when it has to do with substance, but I've learned about a rule used to interpret the amendments, and that interpretation is a problem. I wanted to point that out. I just wanted to have it on the record. But that being said, I don't want us to spend the entire evening on this. We have important work to do.
Thank you, Mr. Fortin. Mr. Housefather?
Monsieur le Président, juste par intérêt de...
Mr. Chair, I just want to ask a question. If there was a conflict in the French version, but not in the English version, I'm talking about line conflict, will it not be the same effect? Because I thought that if you were a chair, if there was a conflict in French or in English, it would be inadmissible or out of order. Is that not the case? Yes, indeed. And in this case, yes, it's okay in French, but if the amendment were to be adopted, there will be a line conflict in English. So the rule is that a rule of the bill cannot be amended in one or the other. I understand. Mr. Chair, stop me if I'm out of topic. G7 intends to add the paragraph, whereas NDP 6.1 seeks to remove one. The two could have been left there. One doesn't exclude the other. Once again, I don't want to dwell on this forever, but I believe that our translations should be done to ensure that the text remains what it is in the two languages. What I read in French is that a paragraph is being added and another is being eliminated. And because the English version, well, in my opinion, when preparing amendments, I don't know about the translation, but I don't think this is a desirable situation. These are two different things. In one case, paragraph 7I is being eliminated, and somewhere else we're adding 8I. I understand that the numbering has to change, and the analysts are good at ensuring consistency. But when I'm looking at the substance, the two, theoretically, if adopted, could have been allowed to be there.
Minutes just to, okay. It's getting late. Everybody's getting a little giddy, I think, but we're getting there. So I understand, yes, I understand we resolved the issue while we were suspended. So I'm going to ask whether shall clause 28 shall carry. No, okay.
So, Chair, I just want to thank the committee for indulging this and taking the time, especially because I'm not a regular member. That was just very gracious of everybody here. I'm not going to move it. I'm not going to move my amendment. I'll wait for report stage. But I have to say, like, this is quite emotional for me because these aren't abstract concepts for our families and communities. This is something that we live daily, and we are the ones that are going to be most impacted by this bill. And to put forward a bill without acknowledgement or consideration of a history and the colonial legacy that it's left, including, as I was sharing with Mr. Housefather, they call it, they've actually developed a name, it's a syndrome. It's called residential school survivor syndrome. And they compare it to veterans and survivors of war. The same sort of psychology. So, like, if we're not taking that into consideration, like when I see a war veteran in a mental health crisis and they do something, like, I take that into consideration. I think what trauma that person must have gone through. We have residential school survivor syndrome in our family. We have the highest rate of intimate partner violence. We have the highest rates of femicide, homicide, of any population in this country. And so I will bring it back on report stage. I want to thank the committee for indulgence, but we've been punished enough to ignore our history and the psychology and the trauma that's come out for it. It's like, when is that punishment going to stop? When are you going to see us and take it as seriously as it needs to be taken? So I'll leave it at that. And I just want to thank the committee for indulging me and the respect that you've shown me. I really mean it. It really means a lot to me. Thank you.
You're very welcome. That's why we suspended, because we wanted to make sure we landed in the right place. So thank you for your comments. Mr. Lawton, did you have you had your hand up a moment ago?
Yeah, so just to confirm, we are now on clause 28 in its totality, right?
Correct.
Okay. I was just hoping to get some clarity from the officials on 264.012C7. And just for context, this is under pattern of coercive or controlling conduct. 2C says engaging in any other conduct, including conduct listed in any of the following subparagraphs, if in all the circumstances the conduct could reasonably be expected to cause the intimate partner to believe that the intimate partner's safety or the safety of anyone known to them is threatened. So point 7 of that is threatening to die by suicide or to self-harm. So I just, and perhaps I'm mistakenly reading the grammar here. How does threatening to die by suicide or self-harm fit into C specifically, which was about the intimate partner feeling like they would be harmed or could be harmed?
Thank you. That's an excellent question. And perhaps it gives me an opportunity to explain this part of the legislation, which is probably the most sort of modern part of it, in the sense that it is directed at capturing or targeted at capturing the more subtle forms of coercive and controlling conduct that we know abusers engage in. And what I would stress is that none of these lists in Romanet I, 2, 3 to 7 can form part of a pattern of coercive or controlling conduct as defined in subsection 2 unless they meet that let's call it the safety test, which Chair has just been read out, so I won't read it out again. But what it means is that this conduct, any example of this conduct must also cause a reasonable person in the victim's circumstances to believe that their safety is threatened before it can form part of the offense itself. So there's actually a mechanism built in to paragraph C to ensure that somebody who threatens suicide, because that could be as has been very rightly pointed out, a sign of mental health problems and not a sign of a coercive controller. But what we do know from the evidence, unfortunately, because we did do quite an extensive engagement process led by Justice Canada with our provincial and territorial partners in 2023, and we did hear from a range of groups, and we did hear that this is a big problem in the context of coercive control from survivors themselves and those who represent them. And I would note also for the committee, in case that helps them in considering why this is here, it also happened in the Bailey McCourt case. Thank you.
So I appreciate that, Ms. Levman. I guess I'm just, there are obviously circumstances in which the clearest one would say, I'm going to kill myself unless you do this. That would be, very clearly coercive control. There are also situations in which someone may be in a crisis. Their intention is not to do that. It may have that effect. And I'm just wondering what, in your view, would save that person who is themselves a victim from being charged if they're not seeking to manipulate, they're not seeking to control, they themselves are experiencing very real issues with suicidal ideation or mental illness. What's to stop that for that person in a relationship from being potentially charged under this when they clearly have their own issues they need support for?
Well, it is, first of all, a modified objective test, so it would have to be, as I said, what a reasonable person in the victim's circumstances would believe. But in addition to that, there is another safeguard built right into the offense. If you look up in subsection 1, a person cannot be considered a coercive controller under this offense unless they have the requisite intent, the requisite mental element. So in the situation that has just been described, Chair, that person simply does not meet the legal test in subsection 1 of 264.01.
Okay. Thank you.
Mr. Bauer?
In that case, Ms. Levman, the committee, I really hope that everyone here heard what the official just said. The safeguard against a catastrophe in a situation like this is the requisite intent. Part of the challenge with the clause, since my amendment was defeated, is that recklessness remains as sufficient element to meet the mens rea, which is why I have proposed that we remove recklessness specifically for the type of situation that we're describing here. Someone says, I'm going to kill myself, God forbid. Let's say if you don't do something, and then how do you square the safeguard that you just described of the intent with the fact that the legislation in clause 28 makes it clear that recklessness is sufficient to make out the mens rea element?
Thank you for the question. Well, it's not the only safeguard, first of all. There is the safety test in C, and there's a lot of jurisprudence that will help assist courts interpreting C, because this test is taken from the human trafficking provisions and the definition of exploitation, and we have excellent case law right from the Supreme Court of Canada on that. Now, to the other point about recklessness, what recklessness means is that the person has to subjectively know that there's a risk that their conduct could have that effect and proceed anyway. And in the case of somebody who has mental health problems, they would not in my view, meet that test. I'd also like to stress that this offence is modeled on Scotland's approach, which stakeholders have said is the gold standard model for coercive control offences, and there have been studies, and those studies have not raised any concerns about victims or others being inappropriately charged with the offence. And I would stress that Scotland's offence includes the standard of recklessness, and that is viewed as an important protective element for victims. Thank you.
All right, moving on. Okay, so clause 28 carry. On division, okay. All right. Shall clause 29 carry? Yes. Carried. Shall clause 30 carry? Yes. Okay, and then we get to clause 31. So there was no change to this. Remember there was going to be. Yeah.
No, it was fine.
Yeah.
Sorry,
So it's out of
no
scope.
change.
Yeah.
Out of scope.
Okay, so NDP 7 is out of scope. So which takes us to
What's out of scope, sorry?
NDP 7.
NDP
Clause
7.
31, yeah.
Okay,
I could challenge that, right?
no.
My mic was on. Okay, G8. Who's that? It's Latanzio, okay.
Yes, thank you, Mr. Chair. So this is a technical amendment. The motion would expand the application of the sexual activity evidence regime, which prohibits the use of evidence regarding a complaint's past sexual activity to support the twin myths. So example, that the complainant was more likely to have consented to sexual activity at issue, or that they are less worthy of belief, to cases involving an offence under any act of parliament that is of sexual nature or committed for a sexual purpose. The sexual activity evidence regime in Bill C-16 would currently only apply to the criminal code offence that is of a sexual nature or committed for a sexual purpose. This amendment would further protect victims of sexual offences by ensuring that the victims of offences that are of sexual nature or committed for a sexual purpose, including offences in other federal statutes, would receive the same protections under the law.
Mr. Brock?
So I think we largely approve and support this amendment, but I'd like to get some clarification from officials. From your perspective, given the expansion of the scope to any other act of Parliament, are there any unintended consequences that we should be made aware of?
I don't believe so. I think the main concern is the Immigration and Refugee Protection Act contains a trafficking offense, which of course can be committed for a sexual purpose. So the intention here is to ensure that that victim gets the same protection of the law. Let's say, police decide to proceed with Section 118, that's the human trafficking offense in IRPA, and not the criminal code offense. Well, without this amendment, that victim would not receive the protection of the law unless this amendment is enacted. So that is the purpose of this, but what it's reined in by, what I think provides safeguards is the test. You have to have an offense of a sexual nature or an offense committed for a sexual purpose in order for the provisions to apply. And I've already explained to the committee what that term means. Thank you.
Thank you. Thank you, Chair.
Brock? Okay, seeing no one else, so G8 carry. Yes. Carried. Okay, which takes us to NDP 8, which I am also ruling out of scope. Which takes us to G9.
That would be me, Mr. Chair.
Okay, Ms. Dillon.
Also a technical amendment. This motion would amend proposed subsection 276.2, which sets out the relevant evidentiary standards for the admission of sexual history evidence. to insert a pinpoint reference to proposed section 276.02, which was accidentally omitted. Proposed subsection 276.02 contains the procedures for part of the process that must be followed when the accused seeks to admit sexual history evidence.
Thank you, Ms. Dillon. No one else? Okay. Shall G9 carry? Yes. Okay, which takes me to NDP 9. Ms. Kazan.
Similar to an earlier amendment of mine, this amendment seeks to ensure sexual history is not admissible as evidence in any case. Legal experts have shared with us that explicitly affirming the state of law on its sexual history evidence will reduce mistakes by making legislative intent even clearer and prevent the sexist practice of invoking a woman's sexual history to damage the credibility of her testimony.
Thank you. Okay, I see no hands, so shall NDP 9 carry? No. Okay. G10. Mr. Housefather, okay.
Basically, this is for a greater certainty clause to codify the 2025 Supreme Court decision in R versus Kinnamore that basically says that Section 276, which is the sexual history evidence admissibility regime, is engaged by sexual inactivity evidence. If anybody requires more clarification, happy to do so, but I think that's basically the intent.
Great. Thank you, Mr. Housefather.
Sure.
Mr. Brock?
To the officials again, a similar question. Any unintended consequences with this amendment?
I'll take that question, Mr. Chair. I thank the member for the question. No, to give a relatively short answer, no unintended consequences are foreseen. This is a codification of part of the Supreme Court of Canada's decision in the King and Kinnamore that came out in 2025, and it is going to provide clarity to practitioners across the country that, yes, sexual inactivity evidence can also be used to invoke the twin myths and is properly captured by this regime.
Thank you again.
Thank you, Mr. Brock. Shall G10 carry? Yes. Carried. Okay, shall Clause 31 as amended carry? Yes. Okay, so we're now into Clause 32 and G10.1, which I believe is Ms. Yeah.
Have it in my
Front of you.
binder right now.
Okay.
Oh, there it is. Sorry, found it.
Okay.
So, moving that Bill C-16 in Clause 32 be amended by A, replacing line 29 on page 19 with the following, prosecutor and filed with the clerk. B, replacing line 37 on page 19 with the following, the prosecutor and filed with the. And C, replacing line 8 to 10 on page 20 with the following. If the judge, provincial court judge or justice grants the application and agrees to hold the hearing, the accused shall cause a copy of the application to be given by the complainant by a person other than the accused. And this amendment is really just about cleanup. It is very, very technical.
Thank you. Shall G10.1 carry? Yes. Carried. G11. Ms. Latanzio.
Thank you, Mr. Chair. So this motion would clarify that victims or witnesses who are protected by the automatic publication bans that apply to hearings to determine the admissibility or production of highly sensitive evidence in sexual offense trials may disclose information about the hearing, including a legal professional, healthcare professional, or a person in relationship of trust with them, provided that they do not intentionally or recklessly reveal the identity of any other person protected by the publication ban.
Okay, shall G11 carry? Yes. Carried. G12.
That would be me, Mr.
Dillon?
Chair.
Okay.
Also a technical amendment. So it removes the words "for a hearing" from proposed subsection 276.061 This technical amendment to proposed subsection 276.061 would ensure clarity that the procedure for the Crown to apply to adduce evidence of sexual activity is intended by Parliament to be a single-stage procedure. This is not a policy change. Rather, the words "for a hearing" were unintentionally included in the bill.
Thank you. Shall G12 carry? Yes. Carried. NDP 10.
That we're proposing was submitted by LEAF. This amendment relates to procedures surrounding the admissibility of sexual history as evidence based on recommendations from organizations like LEAF to create greater legal protections for women and gender diverse people when there is an application for considering their sexual history. This would provide greater notice to the complainant prior to the hearing to determine the admissibility of this evidence and would provide complainants with independent legal advice and standing during this process.
Thank you. Okay, shall NDP 10 carry? No. No, defeated. G13, Ms. Latanzio.
Thank you, Mr. Chair, and that would be the exact same rationale that I used and spoke to G11.
Okay, shall G13 carry? Carried. G14.
So that would be me, Mr. Chair. It's another technical amendment. It fixes a typo in proposed subsection 276.16 by removing the word "the" from as to the uses that they may and may not make of that evidence.
Okay, shall G14 carry? Yes. Carried. NDP 11.
I'm not feeling like if this was a baseball game, I'd feel like I was losing, but I'll tell you what my amendment is. It's similar to my last amendment on the recommendation of legal experts such as LEAF, that this would ensure that the complainant with a clear statutory right to counsel from the outset of the joint application process for the use of sexual history as evidence. This is important to ensure that women and gender diverse people have legal protections to ensure the rights of women and gender diverse people in the legal proceedings are upheld. And I'm wondering if I can ask the drafters, because this is something that was really focused on by some of the women's organizations. What is the issue with, putting limitations on utilizing sexual history as in the courts as part of the process? Like, I understand you're voting against it, but, there's been a lot of research about is it just a line conflict, or is it with the amendments we're proposing? It just, we have, for this amendment, sorry, I'm getting tired. For greater certainty, the complainant has the right to be represented by counsel.
So are you posing a question
Yeah,
to
I'm
the witnesses?
asking a question, a very convoluted, tired question. I really apologize.
No, I was having trouble hearing you. That's
Yeah, I would have a hard time too. Yeah.
Thank you, Mr. Chair. Thank you, member, for the question.
Yeah.
So NDP 11 here would insert a "for greater certainty" clause into the first of the two proposed joint admissibility application processes that are new to Bill C-16 and potentially to the Criminal Code. And looking at the very beginning of that procedure, you'll note that the proposed language in both of the joint application procedures refers to all three, the Crown, the defense, and the complainant, agreeing to jointly apply together. So the position of the department would be that that alone does grant complainants the necessary standing as part of the joint application process. That being said, though, there would be very little legal risk to including a "for greater certainty" clause in the joint application procedures to clarify the fact, because it is unusual, typically, for a complainant to be a party and to have standing, to clarify that fact.
Yeah, so just to follow up, it would provide further clarity with this amendment I'm offering?
Yes, and so
Okay.
a for greater certainty clause can operate to clarify the existing state of the law and make it extremely clear for all justice system participants that this is the intention, and so that's what this would theoretically do. It would provide that clarity if it was adopted by the committee.
So the committee is voting against clarity. Just kidding.
Ms. Kazan, don't,
You're supporting it?
okay, just, let's save the celebration. Let's save the celebration. Mr. Fortin, did you have a?
Merci, Monsieur le Président. Je veux certainement pas être contre.
Thank you, Chair. I don't want to speak against that. Mr. Ellison, we are talking about the right to be represented by counsel for the victim. What does this right entail? Does it involve the right to present procedures, ask for expertise, and so on? Will this not delay the process? Is there no risk of delaying the administration of justice? Second question, if there's a right to be represented by counsel recognized in the criminal code, does this entail the right for the person represented to have legal aid and or pay for their lawyer, have legal aid pay for their lawyer? And are the provinces ready to cover those costs for lawyer fees and to have the process modified? And there's the danger of the procedure being longer. So those are my two issues, my two concerns.
Thank you very much, Mr. Chair, and to the member for the question. First of all, what does this entail in terms of what is the role of counsel for the complainant? Oh, this wouldn't necessarily fundamentally change the role of counsel for the complainant when it comes to these types of applications, except for the fact that these measures are aimed at reducing delay overall. So if there are non-controversial aspects of sexual history that even the complainant agrees after consulting with counsel that can be admitted as part of the trial process, then if we do get, in those relatively rare circumstances, all three parties agreeing, then at that point, we can go through an expedited process as proposed in the bill to have this reviewed by the trial judge. You receive then a response. And if for any reason the trial judge needs to provide further direction or disagrees with the proposed specific use of that sexual history, then that trial judge can compel a normal, what we call a stage 2 hearing, where this would normally be litigated. And the criminal code already provides direction in it as to the role of complainants' counsel, namely that they are able to make submissions on the matter. And the Supreme Court of Canada and other courts have provided specific guidance in this context about what counsel can do. Because it is not necessarily the full rights of, for example, the Crown to cross-examine witnesses at one of these hearings. For the rest of your question, with respect to legal aid, this for greater certainty clause and also the proposed substantive provisions that are in the bill when it comes to the joint application processes would not necessarily fundamentally change entitlement to legal aid in the provinces or territories. So existing criteria would most likely be applied by provincial and territorial legal aid commissions or legal aid societies.
Si.
Thank you.
À ce moment-là, ce que je comprends.
Now, I understand that it's already being done now on the basis of consent between the prosecutor and the authorization from the court. Now, in the criminal code, if it's introduced in the criminal code, it becomes an obligation. The court will have no choice but to allow representation. But you are saying now the complainant's counsel can cross-examine if the judge authorizes that. But once that provision is added to the criminal code, will the judge not have greater leeway if and complainant's counsel may not have the right? Let's understand that everybody has the right to consult counsel or consult a lawyer. But if this is written in the criminal code, and we're not talking about consultations, we're talking about representation, according to my understanding, maybe I'm mistaken, this means there's the right to cross-examine, to argue, file submissions, and so on, and challenge submissions. So I'm not saying I'm against it. But at this point, I have difficulty understanding to what extent we're going by introducing this section.
Thank you again for the question. So just to clarify, the role of complainants counsel within the proposed joint application processes would not fundamentally change, or it would not change what they are able to do in order to assist a complainant throughout a traditional sexual history application. So when the courts have provided guidance that, yes, complainants counsel can make submissions, but there are restrictions on what they can do and what they can't do, and it's not the full breadth that a Crown attorney would have in a sexual history application. For example, a Crown attorney would be able to cross-examine an accused person bringing such an application alone on an affidavit, or related witnesses if it's not the accused person who's signing an affidavit to support such an application. So the role of complainants counsel will ultimately be essentially the same here as in existing law, which is once you hit the second stage of a sexual history application, that is when a complainant has standing traditionally in these types of applications, and that is what would be enshrined here as well. It's just that at the front end of this joint application process, when all the parties agree, we are simply confirming that the complainant has counsel at that point.
Merci.
Okay, thank you.
Thank you.
Shall NDP 11 carry? Yes.
Yes.
There you go. Ms. Gazan, you said let's end on a high note. We will adjourn for tonight, and I'll see you at the next meeting.